All right, and welcome to the dumbest, shittiest, most henta virus infected podcast that has ever existed since the dawn of humanity. Your favorite racist cult leader is here. Will be the host today. Trigger warning. Your favorite Masonic cult leader, 32nd degree blood drinking,
baby killing, all that good stuff. Whatever.
All you gotta do, you just so my particular guest today. Some of you may be slightly familiar with him. His name is Joey Kimbrough. So what he does is he goes out and he pretends to get into fights, but then once it kind of goes long enough and he's kind of had enough. He gives a couple of hand signals, does a couple of secret handshakes, 32nd degree Mason handshakes, and then he magically wins the cases. And that is literally the only reason why Joey has won anything at all. And in fact, I have decided it may be my only path to success. I may follow in his footsteps. I may become a Mason, work my way up to the 32nd degree. That way I can start winning cases. Too, Joey.
I'll get you a petition, bro. We'll come out there. I'll come out to Tranny Land and sign your petition, and we'll do an investigation on you, and see how that goes. And I'll hide the black cubes for that meeting. You don't know what that means, but it's good. So I'll hide those.
Oh, good. Yes.
So you can't get voted out.
Thank you. That's what I need.
When they see one stupid fuck on the application, I'll tell them just ignore that.
No, put racist cult leader on the application.
Oh yeah. Well, then
I'll get approved. See,
you're pretty well shooting.
Boom, stamped.
Yes,
I'll be instantaneous honorary 32nd degree. You know what I
mean? You're ahead of the pack.
Hell yeah, dude. This is great. Yeah. White guy who's a racist cult leader. Shit, bring him in. Why isn't he here now? You know what I mean?
You got the haircut for it. I mean, you got the Aryan Army thing.
There we go. So. I can get a swastika tattoo, like an eye drop swastika right here.
Yeah. I think it's a good look, man. Now, don't do it during Pride Month because I don't know if the needles are clean. You know what I mean? I don't want you coming up with something,
All right, I'll wait till after June.
Yeah.
Maybe for July 4th. Maybe for the independence of our country. Maybe I'll celebrate with a little.
That's a good time. Yeah, 250. Yeah, that'd be a good one. Yeah.
So welcome back to the show. You haven't been on the show in a long time, man.
It's been a minute, been busy with the cohort stuff. I know you've been busy. We've talked on the phone a few times, obviously, and it's good to be here, man. And I hope, I know you shared some of the hearing stuff through the tax court thing that's going on, which is great here in Indiana. But I also have a case that I just got recently dismissed, and like I was telling you before, fucking our hour and 45-minute conversation before we hit record, that it's a good thing, I think, to show some sauce on some of my happenings from a defendant standpoint. I know what your stance is on being a plaintiff. There's no doubt about that, and I'm not saying we go against what I've read my platforms for plaintiffs, and I think that's wonderful. And I think, for me to say that I'm not interested in being a plaintiff would be a lie. As I create a whole fucking cohort and build evidence to be a plaintiff successfully, for 1681 claims. So I would be talking out of a different side of my mouth. But the thing that I told you before is I get more than, but I do 3 consults a week, man. I've really limited my time there because I truly want to get enveloped in whatever it is that we're talking about. Mm-hmm. And 100% of those consult sessions are around somebody being sued. They're a defendant. And I find that's where most of the opportunity is at to help somebody is, it's awesome to build and to be a plaintiff. You learn how to sue somebody. That's wonderful. But I also think it's equally important to learn how to be sued, as weird as that sounds. And there's a whole procedural component there that looks exactly like what you go through as a plaintiff as well. But it's even more important. Instead of like you and I were talking, when you're a plaintiff, The first thing the fuckers on the other side do, the counsel, they start bitching about procedurally trying to snuff you out. There's a 12b6 coming your way, and this is what I teach people in my cohorts: is if they when they as soon as they reach out to you, it's imperative that you communicate with them in a way that you say, hey, let's get on a meet and confer conversation. And at that point, you get past the, hey, your claims are frivolous, they're meritless, and you're a fucking asshole. When you can get past that, you ask them, can I send you a 408 to share with your client? You've got a high likelihood of success, at least in my world of 1681. Because if it's a business decision to where you're asking for, let's say, a couple of $1,000 and to get your credit profile cleared, that makes a lot of sense to an Experian versus, going to the mat with you and potentially having to face you at a trial, which is not going to happen. But if you don't do that, here's the procedural component. You're leaving them with no other option than to file to 12b6. So if everybody had a homework assignment they wanted to do tonight, go look at your state court civil rule of procedure 12 and also the federal rule of procedure 12 and read that. And you'll read in there that it says prior to, and I'm paraphrasing here, prior to answering or defending a pleading, you must defend. So it's telling you and putting you on notice. And again, I'm paraphrasing there, but it's telling you that if you want to, prior to answering, then that's why they never answer your fucking complaints, because they're always trying to snuff you out. So if they get a 12b6 docketed, there's 6 months now that you've got to deal with that fucking horse shit, just in the fighting, the back and forth, and waiting for the court to approve for you to go forward. If you've had the conversation, the meet and confer prior to them filing that 12b6, the likelihood of your success in getting out of the case really fast is very high. Now, on the other side, so that's you being the plaintiff and them trying to attack you procedurally. When you're the defendant, you now switch the hat. They're in there bitching about, oh, in the state of Indiana, we're always, Your Honor, deciding cases. It's always been that way, that they're decided on the merits, when you're sitting over there from a procedural standpoint trying to get them out of the case. So it's a chess game that I've found. And the case that I actually just got taken care of, got dismissed, was that in itself. It was just for a little bit of background, you and I were talking about. It was a UACC, is the name of the company, United Auto Credit Corporation. They were one of my subprimes when I owned a dealership. They're based out of Orange County, California, and they had a judgment against me, in my dealership days. So for 20-something thousand, one of my clients didn't pay, and then, I had signed a personal guarantee for, the line of credit that I had. So them not paying, they came after me. So they got the judgment in Orange County. Well, I don't give a fuck, and they can't they can't collect on it in Orange County when I'm sitting here in Indiana. So they brought it across as like a sister thing and filed the foreign judgment here. And there's just so many, as we go through it, you'll see there's so many procedural irregularities or inaccuracies that I point out right away, and I start asking. And what happens there is the judge calls a hearing, and the judge does what he does, which anybody that's litigated knows this. If you're a defendant, gets you in there and tries to talk you in circles that you don't know what the fuck you're talking about. That's kind of the MO. So it didn't work, and long story short is I was able to procedurally get rid of them. Now, I had to, it was a journey, because that judge says he's going to make a ruling. He didn't do that, but I had the wherewithal to go to the 53-1 rule, which in our state, and I'm going to say most states, talks about the timing that you have to make an order. So literally on the 30th fucking day, because that's when the timing told, I pulled it away from him, sent it straight to the Indiana Supreme Court in what's called a praecipe, which is, if you look that up, it's a writ. A writ's a command. So I'm commanding the fucking clerk, which if you follow the rules, when I'm doing that, filing that praecipe, I'm telling the clerk, you're commanded through 53-1F to send this to the CHOW, the Chief Administrative Officer of Indiana Supreme Court, to get a decision. Well, what'll happen 9 times out of 9 is the clerk's going to ignore you too, as they will do. And most people are in there and they don't know how to move. My shit's not moving, Uncle Joey. Well, it's because you don't know how to drive. The keys are in your hands. You just don't know how to drive. So at that point, then now I wait another 6 weeks, I think you'll see, and I file a motion to compel. Boom, judge signs it right away. And now he's telling them to send everything to the chow. He knows he's fucked at this point. So it goes down there. They sit on it for another, I think it's 2 or 3 months, and finally decide with me, as you'll see, that says, you're right. We're going to give you a new judge, bro. So it comes back. I get the new judge. The new judge does his horseshit game and says, hey, if you counsel, which I'm not, if you have any questions, you want to set anything for hearing, Dana Kelly is your gal. I don't want to do any of that. Fuck you. I fucking created this motion to renew outstanding motions and showed him what's there. And I included a proposed order granting every fucking thing I wanted, which you'll see, including the dismissal. And it had happened. So there's a whole procedural process there. You have to know certain components of the rules. Know there's some lines there in the sand that this thing could drag on for years and years and years, as long as they want to keep it in the court. Until you're in that instance. I think it took me a little over a year to get that thing dismissed. As crazy as that might sound, it's like just going through the motions, and getting everything taken care of took some time, and that's the thing that I think a lot of people get frustrated, rightfully so. They don't know the proper rules. And the thing that you and I now know, Brandon, is like, there are so many tools that are available through AI to help you, at least through the research. I wouldn't say let it write everything. If you can heavily prompt knowing what the rules are and what it is you're asking for, and the components of building out stuff, it's okay to use. I don't trust it because it hallucinates, but I will trust it, as you and I talked about, to move some fucking big mountains as far as research goes in a matter of moments versus hours, if not days. So,
if not months or years. I
Oh,
remember the
sometimes.
first time I tried using AI for like the sixth, seventh, eighth time, and you gave me Perplexity, and I didn't want to ever. Cameron Wilson gave me this other one, and everyone's talking about it and this and that, and then finally, I went to Gronk one day and I typed in, "What is the very first case where corporations were considered persons under the 14th Amendment?" And I thought for sure it's going to give me trash hallucinations. It popped up. It said the exact case. It gave me the exact quote of the case. And I was sitting there and I was like literally stunned. I was like, this can't be real. And so I go on to Google Scholar, because that's all I knew at the time. And I type in the case and I look it up and the quote's there, and I just about died. And I've been using AI ever since.
Yeah.
I don't even know if you would have given me a month at the local law library, if I would have found that. I don't know. I wouldn't know if I would have found that.
Yeah, if you know where your mind is, like, from that defendant standpoint, when I get the documents from them that I'm being sued, just doing something so simple, most people can just upload that to a Claude or a GPT, whatever you want to use. I use Claude now because, in my opinion, it's the best. I've really been transitioning to it because I think it's a better product from a formatting standpoint and the whole bit. But anyway, if you upload those documents and just start talking to it conversationally, like we're doing here right now, not create me a fucking motion, kind of thing. It's no, I tell it what I'm thinking. And then I say, if we're not aligned, ask me questions. And it's got a really high propensity to ask you the right fucking questions too. I did this the other night and it was kind of eerie in my cohorts. Is I said, hey, I want to do some building. And a gal's having some issues in her case. So I brought her stuff in and showed, here's how I build it. I want you guys to see me doing it live. So doing that, and before I even get started, the shit happens like that, but it takes me a while to get it, the context built of what we're talking about, getting everything uploaded and having a conversation with it. I think it's wonderful, like Brandon was saying. So in this instance here with this case, for me, uploading the documents and say, hey, here's what I think's going on. Ask me questions. Let's have the conversation, and boom, you can find out right away. Hey, they're fucking up this statute right here. That's how I found it. It's like statute 3335-4 says that for them to bring across a foreign lien to file in the state of Indiana, an affidavit has to be signed by the party. Think about that. And I'll show you here in a little bit where that gets fucked up. It gets fucked up because the attorney says, this is my affidavit. Think about that. He's the fucking attorney with no firsthand knowledge. He's not the party, and the statute clearly says who the person is. So when you see things like that and you're getting those nuggets, even through the research of AI, you still have to be able to put that together to see his affidavit says it's his affidavit and he's an attorney. He's not a fucking party like UACC is. So, I mean, just little things like that, you can kill him. And there's other things. I mean, there's much more novice, if not beginner, things that he fucked up. In the video I shared with you, I'm much more ramped up in that than I am here talking about this Ohio attorney and stuff. He came over, he didn't file an appearance. That's a big no-no in Indiana, any state, but for that matter. It's not just Indiana. Locally, get to know your local rules and get to know your state rules of civil procedure, right? You'll hear me a lot of times say 4 buckets: civil rules of procedure, rules of evidence, judicial canons, and the professional standards of conduct. There's other things that go with that. Your local rules, wherever you're at. I'm in Howard County, Indiana. Pull those out and upload those and stuff too, and just have conversations. Hey, what's it say about? And you'll see that in here. The local rules are very clear: must, shall. There's a lot of that that's said. That's mandatory, and there's no discretion there for the court. So that 41E was a rule that you'll see me, and that's 60 days without prosecuting. Failure to prosecute. So I cracked them in the nuts with that one too. So failure to prosecute, not having an appearance filed, and then that statutory stuff with the affidavit that they didn't have from the party. It came from the attorney. All of that, any one of those things was enough to get the case dismissed. But then getting the judge in there, it's I wish you guys could hear that stuff. When you're in the courtroom, I'm not being disrespectful, but I'll take it all the way to where he's got contempt on his lips. I'm pissing him off because I'm telling the truth. Mr. Kimbrough, 41E is reserved for the courts. It's a way we can clean our dockets, if you will. And I'm just sitting here fucking grinning at this point. Now he's getting really fucking mad. And I said, I don't see in there. Let's pull that up and read 41E. It doesn't say anything that's reserved for the courts. It's for me too, bro. So anyway, if you don't push back on that, guess what happens there? 41E is reserved for the courts. That's the key, is you have to challenge them when you know the truth. You've got to, and I think that's where a lot of people get flustered and they start fucking rattling off, and especially when they're in a court. And I get it. You're in an environment that's not yours. You've got some people that are there that have some very goofy energy. And to be real honest, to not sound goofy, you're the fucking light there, bro. Not to get into too crazy, but you've got everything that's the truth, and you're gonna keep being told no. And here's what they do. Brandon knows this more than anybody. Is when you leave, it's like, well, I'm gonna go ahead and take that under advisement. That's their way of getting the fuck away from you. I'm gonna take all matters under advisement. Well, as it happened in this case here that I'll share, is nothing happened. I'll have you guys in order by the end of the week. Well, the end of the week came and went. 30 days came and went, and he's not going to do anything with it, by the way. He doesn't want to. He knows he can't do what he has to do. So the only thing I can do is pull it from the motherfucker, send it to the state of Indiana Supreme Court, who ultimately kicked it back. And when I get the new judge now knows that he's going to have to, in the way he tried to avoid it too, was to say, hey, set up some hearings and all that dumb shit we do. No, I'm just going to renew all the other shit that's not been ruled on. And I'm going to give you a proposed order that you should be signing real quick. And he did. So, and not from a place of arrogance, but I sent the letter, that order, and some words to UACC and said, hey, look at this order. This is the last time we're going to be talking. Next time it's not going to be so nice. So fuck off, leave me alone kind of thing is what it was. So, that's just kind of a 30,000 foot overview, and it's a short docket, but it extends over, I don't know, I think 14 months or maybe even a little longer than that. But it's one of those things where I sit there and watched it on the docket for 8 months, and I brought that up in the hearing. You filed this thing in February of 2025. I think it was October before I even filed an appearance. I'm going to file an appearance because I'm going to follow the rules. I'm going to file my motion to dismiss pursuant to 41E and, all of that stuff. So we can go through that stuff. I mean, if you want to go through that, I think there's some sauce there for people to be able to see and know how to maybe pivot, navigate, all of that stuff. What do you think? Yeah. Okay.
Oh yeah.
Let's do it.
I thought it was a rhetorical question. I was like,
let's do
it. Fuck yeah, that's why you're here.
I haven't. This is my Amex case. Let me pull it up. I know I'm not sharing now, am I?
No.
Okay. Now you want me to share the entire screen, I think, don't you?
It'd be easier. You can just kind of cruise around without having to think about it too much. It's up to you.
No, that's good. I don't care. It's going to be 1,000 tabs. Okay, here we are.
Tab land.
Tab land. Holy
Tab-teenth.
If you come over to Indiana, you're more than welcome to do so, by the way. mycase.in.gov, I drag people to all the time. Create a case, it's free. Type in my name or anybody else's for that matter, and you can see at least all the stuff that I'm talking to you about today or anything else. It's free too, by the way. Any of my pleadings, these are all my cases. This is one of them that I'm talking about right here. So the reason why I get a little wound up about the negotiable instrument stuff is this right here.
Do you now?
Yeah, this is the perfect example. You'll see here United Auto Credit Corp versus Joey Kimbrough and JMC Auto Works. That was my dealership in Indiana. So I had signed a personal guarantee for that dealership. I did not have access to the Federal Reserve window. It just drives me nuts when I hear that. And neither did these guys, my lenders. So they're suing me and my dealership, which at this point had been disbanded. And yeah, that's just a very quick overview of kind of my thoughts there. Not
quick note on that. I've told Joey this. I'm going to say it again. First and foremost, any note or draft has intrinsic value. What they do with it is irrelevant. You're going to see that in my first amended complaint that I just filed into the City of Glendale case. Covers that in great detail with a flow chart and everything. Second thing is the Federal Reserve Master Accounts and Services Database, which I'll do a super ultra quick screen share on that. I'm going to close your screen share for just 2 seconds because I would like to.
Yeah.
Did it close your screen share?
It did not. Oh, I don't know. I don't see what you're saying. I don't know.
Let me see. Can you close your screen share? And then you should see mine once you close it.
I think I did close it.
So can you see my screen right now?
Yes, I can.
So if you go to the Master Account and Services Database, you can just type that into Google, and this page should come up. If not, the URL is right here, federalreserve.gov/payments/master account and services database about with hyphens in between each word, .htm. You're going to go to existing access, most likely. And then you're going to type in and fish around and see if you can find the name of the bank or federal credit union you believe has Federal Reserve discount window access. AG Texas. That's one of the ones that I checked a long time ago. Now it's not coming up, ironically enough. But for the City of Glendale case, I typed in Glendale. I found Glendale Federal Credit Union, clicked Submit. And I actually submitted this as part of evidence exhibit B in my case, showing and proving I don't even need discovery. I need no discovery to find out if Glendale Federal Credit Union has discount window access. They've had it right here since May 14th, 2003. Why did I choose Glendale Federal Credit Union? Randomly, someone actually commented on one of my comments something brilliant, telling me that there was this Federal Credit Union that literally said right on their website that they exist for the public utilities in Glendale, who we are. Since 1951, Glendale Federal Credit Union has been helping the public service employees of Glendale reach their goals. So it was literally like the golden basket. But this is just a presumption that they can now take the instrument that you gave them. But whether they go to the window or not, giving them an instrument is a payment either way, just to be clear on that.
Mm-hmm.
If I give you an instrument, I don't give a fuck if you go to the window or if you wipe your ass with it. It's still a payment either way. Mm-hmm. I could care less what you do with it. Even if you think it's not worth anything, I don't even care if you do that either. It's all irrelevant. The whole window, the idea of the Federal Reserve discount window is just to add substance, to add more information, to give more of the story of what may be occurring.
That's the key. Maybe.
Them doing it or not doing it is fucking irrelevant. If I give you a note or a draft, I have given you a payment. Yeah. Period. End of story.
Yeah, I don't dispute that at all. I'm saying that all these dumb shits that are taking this and going to the Joey Kimbroughs of the world are causing Joey Kimbrough a lot of grief because Joey Kimbrough's getting sued. So
well, yeah, you can't if you're gonna presume they're going to the window, you should try to look around and see if you can find some nexus. Like, for example, if it's Joey Kimbrough dealership, I'm gonna go on to Joey Kimbrough dealership, or I'm gonna call Joey Kimbrough dealership and be like, hey, what kinds of financing do you guys use? Or if I was going to come in and I was going to get a loan, what kind of financing do you use? Or if I went in and I got financing and they said I was denied, can you please give me a sheet of all the people that denied me? And then what you're going to do is you're going to take all those names on the denial sheet. You're going to go to the Federal Reserve discount window master account and services database. You're going to type in each one of those financial institutions into that database. And if they all have access, great. If none of them have access, then that's not an argument you should be filing into a case. Mm-hmm. Just to be clear.
Yeah, I don't disagree with that at all. I just... anybody that thinks they're going to come in and do a special endorsement in a dealership that looks like mine is causing a tremendous amount of grief because I see it. All these dumb shits are saying, "Oh, these fucking dealers got access." No, we don't, you dumb fuck. I'm showing you literally a case here where a lender is fucking suing me because your dumb ass didn't make a fucking payment. To them. So, I mean, there's a whole disconnect there, even above and beyond all of the frustration to get. I've said this openly, and I believe this implicitly, is if you're going to go down that path, and I'm not telling anybody what to do. This is not legal advice, and I can say that in real time. I give legal advice, by the way.
Me too. Hell yeah. Ninth Amendment, bitch.
It's like, if I were telling you what to do and I'm not, I would say go research TILA, Truth in Lending Act. That's 15 U.S.C. 1605. And I would tell you to look at the repossession laws in your state. And if you do those two fucking things, TILA is going to give you, I'm telling you this from experience, by the way. If I'm telling my sales guys to move metal, they're fucking moving metal. They're going to get it through the finance office and they're going to do what they got to do to close the number of deals that Uncle Joey wants to get done. I'm telling you this from experience. There are going to be a lot of mistakes that are made. There are 3 disclosures 1605 clearly tells you that are supposed to be done. I didn't give you one of those fucking disclosures. We just went right on past. So, I mean, attack me from that angle if you're going to be pissed and want a fucking free car or whatever it is you're going after. Attack me because the sheriff is fucking stupid on how he repoed your car and he clearly outlined, acted outside of what the repossession laws say he's supposed to do. Above and beyond that, the dealership here is responsible too to let you know that it went to fucking auction, it was sold, what the different was, and what you. There's so many things that happen with the repossession laws that are in your favor. The laws are built for you, just like I teach 1681, 15 USC 1681. Those laws are for you. I mean, they're built
Yeah.
for you if you know them. Tila's built for you to avoid the shit that I'm telling you we did in the dealership days, and I'm telling you the fucking sheriff is doing, and the tow company and the fucking dealership and the finance arm and all of them. If you know repossession laws and you know Tila, you're going to do very well. And I'm not telling you what to do. I'm just saying, fuck, dude, go the path that's going to be the path of least resistance, where you're going to have the highest probability to file a 1605, lawsuit, or and that's what I would do, and I'm telling you from experience there. I think a special endorsement with a negotiable instrument is really a tough hill for you to climb, and you're hurting a lot of other people in that process, mainly the me's. If you're going to crack me in the nuts, crack me in the nuts for something I did to you that was wrong. And I'm telling you, Tila is where I got you.
Well, the other thing is too is that technically the issuer of a note can't negotiate the note. If you look up the definition of an endorsement, a drawer, a drawee, and an acceptor may not endorse an instrument. So technically speaking, when you write without recourse on a note where you are the issuer, or should I say the sole proprietorship is the issuer, you're not allowed to really issue notes like that legally, because state citizens fall under Article 1, Section 10. You can't tender anything but gold and silver coins in payment of debts. That's kind of why the sole proprietorship sits in between you and pretty much every transaction in your entire life, because the sole proprietorship can only touch legal tender, and a state citizen can only touch gold and silver coin as per Article 1, Section 10 of the Constitution, which is all kind of new. I broke all that down in my first amended complaint in the city of Glendale. But you are signing on behalf of a sole proprietorship. That sole proprietorship is the issuer. The issuer cannot endorse the instrument. So I know I taught that for a long time, and technically, yeah, you can write whatever you want on there. You can write without recourse, whatever. But what I find so funny is technically, that without recourse really doesn't hold any real weight. If you look at the UCC, it says that an issuer can't endorse a negotiable instrument. And because without recourse is technically an endorsement, it's a qualified endorsement, it really has. So they're denying you're putting a qualified endorsement on a note that's being issued that really can't have a qualified endorsement on it, and it literally has no legal basis and meaning. And what's so funny is they're acting as though it does. So the bank flips out and they go, "Oh no, we're not going to touch that." But it's funny because now that I know that it doesn't really have any weight to it, I laugh kind of almost in the other direction. It's like, well, why is the bank making such a big deal out of it then? If it has no, because really the way that it's supposed to work legally, if you did put without recourse, is the bank can just ignore it, because the issuer cannot endorse an instrument. They just ignore it, and they just collateralize the note, go to the window, sell it, trade it, whatever they want. What you want to do is you want to get a bill or a payoff statement, because once you get the bill or the payoff statement, that's when you can actually endorse the instrument. That's when you can become the endorser, is when you get the bill. You can't endorse when you're issuing a note. But when you receive the bill, you become the holder of the bill, then you can endorse it, and then you can tender that as payment. So technically, you can go into any of these car dealerships. You can sign just normally without recourse. You don't need to put anything on it. It's all irrelevant anyways. Even if you did put without recourse on there, it really doesn't have any legal basis, because you're issuing the note. The sole prop is issuing the note. Get the whole thing opened. Get the bill sent to you, become the holder of the bill, get a payoff statement or whatever, endorse that, send that in, and then now you can sue under the California code of your state based off of section 1305, which is what you'll see. That's exactly what I just did in my First Amendment complaint in the City of Glendale case. 1305, or UCC 1-305, is the section that allows you to turn anything in the entire commercial code into a cause of action, and you don't even need damages. It says right in 1305, you can't collect any relief on damages, but when you dig deeper, that also means you don't need damages to even structure a cause of action. So if you endorse the bill and you send it in and they don't charge you, even if you aren't damaged, you can sue them immediately. You don't need damages, which is fucking huge. But that is the super ultra technical, super ultra truthful breakdown of how this all works. You can put without recourse on anything you want, but if you're issuing the note, that qualified endorsement does not actually hold legal weight. And it just goes to show you, do the banks not even have any clue about that? Because when they see it, they freak out, but it's completely irrelevant. Why are they freaking out?
Well, I mean, you're going to find this. I'm listening, and I can't take a properly or non-properly, it doesn't matter, endorsed instrument as payment, like I think some people think, and be able to take that to the bank. Now you've said the same thing there about the bank. They're fucked up just like I am. None of us are taking that as a payment to say, great, I'm going to give you this metal that I actually paid X number of fiat dollars for. All of that's very real. And then taking this specially endorsed thing and having to deal with this, because I can't cash that in to the bank. The bank's not able to cash that into the window, evidently. I just think people are going to start, as people know now, are going to start looking at you like you're a purple-headed monster when you're speaking in that language, because for us, fiat, non-fiat, doesn't matter. It's something that I can't spend for something that I bought. You know what I mean? It's like, it's just not in my reality, at least as a dealer in the banks that I deal with and so forth. So
once you get the note and you feed it to the finance company, the war from that point forward is between the buyer and the finance company, though.
And you just saw them suing me now.
So what I'm saying is that you can just go in and not even use without recourse because it's fucking irrelevant anyways. I mean, you can use it if you want, but technically it's irrelevant because you can't endorse when you're issuing a note. It's not you, it's the sole prop, but I'm just going to be very, very, I'm going to make sure I'm very specific so I don't get anybody lost. It's not you. A state citizen can't issue, a state citizen cannot make a payment on debt using fiat. It's physically impossible because it violates Article 1, Section 10 of the Constitution. You can't tender any payment on any debt that is not gold and silver coin. Can you be paid yourself? Maybe. It depends on how you look at Article 1, Section 10. If you want to get really, 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 really specific, no tender on debt. I think of it more as an outgoing thing. I think of it as like you're not allowed to pay any of your own debts using anything but gold and silver coin. I suppose you could possibly also think of it as you wouldn't be able to get paid. I don't know. I don't know how you'd look at that. Maybe that requires more looking, or maybe you need... That's something the courts should be figuring out, right?
Well, and I think there's not a disconnect there. If somebody wanted to, instead of bringing me a negotiable instrument and saying, this is your payment, if they wanted to bring me gold and silver, I'd kiss them right on the fucking forehead. Maybe even lips if I'm in tranny land. I don't know.
The problem is that because your corporation is a 14th Amendment citizen, your corporation is not allowed. It's legally not allowed to process gold and silver coins.
There in itself lies the problem.
We
can't do business together.
That's correct. So the 14th Amendment citizen, the Gold Abrogation Act, you'll still find it in Title 12. It's still there. Technically, even to this day, it's illegal for U.S. citizens and 14th Amendment citizens to even hold gold. They
Yeah.
act as though it's not. They act like it's all okay now. Oh, we're past that. That's old news. It's still listed as a fucking statute. As far as I know, it's never been repealed. And silver, to my knowledge, is pretty much in the same category. If you look at 31 USC 5103, it says foreign gold and silver coins will not be considered legal tender. They're not considered legal tender. So you really have two different citizenship classes with their own currencies or their own money or however you want to explain it. You have the state citizens, and they're under Article 1, Section 10 of the Constitution. No state shall make anything but gold and silver coin a tender in payment of debts. Nobody, where did that go? Nobody talks about that anymore. Did they cancel it? No, they never canceled it. Where did that go? Well, it's with the state citizens still to this day.
Yeah.
And then you have the 14th Amendment citizenship class, which is tied into the District of Columbia. They use legal tender. And that's where everything gets so confusing. What's legal tender? Legal tender is defined in UCC 3-104. There's two types. There's two types of legal tender. There's the unconditional promise to pay, and there's the unconditional order to pay. Those are your two types of legal tender. There's two types of legal tender. Notes and bills.
No, there's no disagreement there at all, Brandon. It's like, I think we're going to the same spot to say, those black citizens like me that are 14th Amendment and proud of it and have it tattooed on our buttocks can't do business with a state citizen. And there in itself is there's not been anything to bridge that gap to say we can work together. We're operating with fiat, and gladly so. We buy missiles, we blow people up, we do all that fun stuff. And then people with gold and silver are doing whatever they do, buying cows and chickens and shit and bartering and all that, like we did in the old days. It's like, what? That's fun. But there's no bridging of the gap there that says that, okay, we're either one going to recognize fiat or we're going to recognize gold and silver. I understand what the statutes say. I understand 100%.
The bridging of the gap is the sole proprietorship. That's actually why I believe the sole proprietorship was created, was to bridge that gap.
And there in itself causes the most confusion of anything, because how many people know what a sole prop and the difference between the two. And then someone like me who's done an extensive amount of trust work from a trustee standpoint realizes as much pain as you do that taking in my trustee role, and I'm still managing one of the two, to the fucking real world and saying, hey, I'm here as a trustee acting on behalf of this trust and talk. I have to train the banks. I have to train the financial advisors. And crazy enough, I have to train the attorneys in that role. So it's an uphill battle that if anybody that has empathy with you, it's me. I understand that. Arguing that from that side is very frustrating. And it's very real too, by the way, because I'll sit down and I understand it more than probably most, and I'm just saying that if I'm in commerce, and I am, if I open up an LLC in Indiana, that motherfucker is in commerce, even if I want to jump up and down and say I'm not, so it is, and it's going to operate, via fiat and all of that other good stuff. It's like, the confusion with the most people that I see is, how do I operate in this world where you're telling me that, because by the way, I don't have a driver's license any more than fucking, a camel named Ted. I'm not going to have
Thank
fuck
God.
You and your license. And
that's one area that you and I are in
100%, bro. I don't pay fucking income taxes because I don't have any income. Fuck you there too.
Another 100%. Another 100%.
Yeah, 100%. We're aligned on so many things that it's like when people come to me, and I've had to live through this, there's a real hard line there for me that it's hard to get past to say, yeah, I'll take your negotiable instrument and I'll fucking deal with that, because I'm over here operating on the commerce side, having an LLC, and you're seeing the fruits of that by seeing me getting sued and dealing with that. I have no problem being sued. I enjoy it. But most people, and I'm speaking for most people, I feel like here, don't have that penchant for fucking litigating, whether it's a plaintiff or a defendant role like you and I do, and maybe some others.
Well, I've also said it many times too, I don't believe that my information and what I teach should be used on small organizations. I believe that what I teach is pretty much solely for I can't force anyone to do this, but I believe that it is truly the technology of David versus Goliath. I believe that's really what I do. I create the technology for David versus Goliath battles. When you take this kind of technology and you go and beat up mom and pop Kimbrough on the street corner selling cars out of their shack,
Yeah.
I don't think that's cool. I don't think that's good because you can tank that whole organization. That whole organization's operating on an 11% profit margin. They've been payment to payment barely. You know, they may have 3 months of reserves, maybe if you know, and you can just tank someone like that using this kind of technology like that.
Yeah.
They're done. They're cooked.
Yeah.
I mean, it's like a giant missile. Like, I think of what we're doing is like we're shooting off missiles and we're shooting at this juggernaut. It's like a ship the size of like a zip code, like an Amex or a government organization. Your missiles are going to hit the side and it's going to need 150 missiles to like maybe start getting some drops of water coming into the hull. Oh shit, we've really got a problem here, boys and girls. Whereas when you start shooting missiles at the tugboat, it's literally a fishing boat with fucking paddles, and you hit them with one missile, and there's just chunks of flesh, you know, and there's sharks coming up to eat up the that's not really what we're trying to do here. We're not trying to destroy the world. That's like world destruction level shit, basically. You know what I mean?
Yeah. Yeah, it's you know there's some agreement there definitely that you know I'd love to see Amex blown off the face of the earth, and then you can start getting some smaller mom and pops and taking it back to maybe what it used to be with the Kimbrough dealers on this on the square. So we're getting more and more away with that, and we're from that and going more and more to the Walmart model and the Amex and all of that other good stuff. And unfortunately, I think that's where we're headed. More so than ever. And I can tell you from experience, and this was said to me yesterday in my Amex mediation, which we may or may not go over, I don't know. But, you know, you're taking on the 800 or the 1,000-pound gorilla. You know, I'm happy to do that. You know, I'm not going anywhere, and I'm not scared of the David and Goliath. I'm not saying that arrogantly. I have all the time in the world, and they want to burn up a lot of resources, and that's why a lot of people too haven't ever taken this stuff on, like you're talking about, Brandon, and taking on, because one, you're not going to find an attorney to chase down, you know, your crazy rabbit hole thoughts of stuff you want to try in the courts, like me too, you know, and even if you could find them, how much are you going to spend over the last 4.5 years, like I've been in this case with Amex at Indiana State Court? It's like, fuck, dude. I would have already spent $100,000 just defending them on a $15,000 fucking debt they think I owe them. So that's
if you're a billionaire and you just want to experiment, then the attorneys will be thrilled. It'll be the best phone call they ever had. Hell yeah, I'll be your experimenter.
That's not the reality.
Actually, most bar cards probably actually wouldn't still do that because they'd probably still be worried about getting their card pulled.
Yeah, getting their card pulled, or just, you know, it's just. There's an energy there too, man, that, you know, most people that call me are getting, this is going to sound goofy, but believe me, there's an emotional reaction that everybody gets when they're being sued. Oh, bro, Capital One suing me for $1,350. And when I get done laughing about that, it's like, you're fucking shitting me, right? You know, oh no, fuck, dude, I just got delivered my shit today, and what do I do? $1,350. Fuck, go learn the shit or pay the fucking bill, one, or you know, get the judgment, work out a payment plan, or go learn the fucking stuff and learn how to defend yourself. It's like the goofiest shit.
That's the best thing that could ever happen, because even if you lost, who gives a fuck? Just go in there and just fucking sling shit. Go in there, dress up like a fucking furry and walk in there. You know what I mean? I mean, you could do anything. with a
Or,
$1,300 lawsuit. You could walk in there in a mankini and see what happens.
exactly.
If
And
you get
that's what,
contempt, you're only going to be in prison for like 24 hours. So fuck it.
right.
Might as well go crazy at that point.
They're, they being the opposing counsel, the ones that suing you and hoping to get the judgment because you don't know what's going on and this, that, and the other, which is a high percentage of court cases that are filed. That's what they're used to, and then they'll get their fees on top of it and this, that, and the other. If you just file an appearance into the case and answer the shit, you've done more than 95% of the people out there. You've truly moved the needle in your case to be able to get it drug out until they're tired of paying. Think about that. They've just paid some fucking bar card something to collect $1,350. Now you're smart enough to know that even a cheap lawyer, 350, you better hire Sal kind of thing, $350 an hour. It's not going to take many hours of answering your shit. So every time you file something, they've got a counter. So they're going to crack them for an hour. There's a 350, 350, 350. It becomes a business decision at a certain point. So I tell people, dude, anybody that's suing you for 10K and under, it's laughable what they'll walk away from. I see offers all of the time, settlement offers, for debts 10 and under. That's just like pennies on the dollar if you know how to talk, if that's what you want, or you can fight it until the end of time like I would, just because you enjoy the game and stuff like that. So they're looking for a quick judgment. They're looking for a proceeding supplemental after that. They're wanting to pull you into the court and start the collection process. And it's a pretty simple collection process. Hey, Mr. Williams, what do you own? What assets and stuff? And if you've done everything right, which I know Mr. Williams has, and so have I, you don't own $1.36. I'm sitting in a nice house here, but I don't own it. My wife's trust owns it. Irrevocable trust owns it.
Yep.
Well, what are your bank accounts? I don't have any of those either. She's got those. I got $1.36 here. What? Fuck, I'll give you the whole thing, bro. It's like
I've got gold and silver, but if I hand it to you, you go to prison. How about that one? I'll give you gold and silver, but if you take it, that's why when you guys, all these people, they offer gold and silver, and they always say no. And the reason why, I don't even know if they even know why they say no. Because if they say yes, they're going to prison. If you offer gold and they take it, they go to prison.
Oh, dude, yeah.
Oh, no problem. Here, I'll pay. Here you go.
Here's a Kruger end. Yeah, that's funny.
And then as soon as they take it, you file with the FBI that they violated the Gold Abrogation Act. They're a 14th Amendment citizen. They now possess gold. You issue the evidence that they've taken the gold from you and it's now in their possession. And if the FBI doesn't press charges and go after them and start trying to put them in jail, then you sue the FBI for not doing their job. If you want to go that fucking crazy, you can go that fucking crazy. It's illegal for a 14th Amendment citizen to possess gold. As far as I know, they can't possess it.
And it's funny you say that, and there's so much time that I've been blessed with being able, it's not going to sound crazy, spending with attorneys, but now more importantly here lately, Brandon, is banks. I've been in a bank, BMO specifically, countless hours, and that trust account that I'm talking about, somebody cracked the fucking debit card the other day. So they hit it for 3 fucking charges of $15 for Audible. Well, fuck, I'm not buying
Stolen?
Yeah,
Okay.
they hit the
Fraud?
fucking debit
Okay.
card. So I go in because the email I got from BMO and the fucking text call, it looked like a fucking scam as well. So the local branch is just right down here. So I went in and I got to talk to like the cyber fraud guy who happened to be in town training people from Noblesville. And he and I get in there and we're having that conversation. I was like, damn, bro, are you going to go after these motherfuckers for those charges and stuff? And he's like, no, he shuts the door. He's like, we'll never go after them unless it's like 5 million and above. He said the first 8 numbers of the card, we own those. And then everything after that, that's what these fucking camel jockeys are over there trying to spin fucking programs to find your digits. And then when they hit, they fucking crack you for little amounts. And that's what they were doing. I was like, oh, I didn't know how that works. He goes, bro, we're just going to fucking give you the $15 times 3. It's not even worth our time to build up the, so the way why I'm saying that is you're going to crack somebody for the gold coin or whatever that is, you're going to have to be the one. Now you would put the work in, call the FBI because you want to go down there with a fucking lime green suit and act crazy. I would do the same thing, but
It would need to be like even someone like Carl, I wouldn't do that to. That's just horrible. You know what I mean? Like it would need to be like if I was interacting with someone and they were just like truly evil, or I knew that they had like some kind of, child diddling secret stuff going on,
yeah.
and I knew that they needed like the fucking, they needed like the fist of God, maybe I would kind of go down those kind of roads. But when I talk like this, I know people get mad, and I know people want to get emotional, and I hope people kind of are able to kind of reel that in to some degree, because the amount of power and force available with some of the things that I say is so tremendous that it's not for daily use. It's like having a nuke. You don't just talk about shooting it off at people, Giving somebody a gold coin and then following through and making sure they go all the way to prison for it is a very extreme, almost humorous example.
Yeah, people, I mean, even if that was something that you were entertaining and you wanted to do, I'm just saying that, you and I know how many people are interested in filing lawsuits about anything. To do that, to make that complaint at the FBI, I've been to the FBI. I've been interviewed by the FBI because they wanted to crack my fucking mayor here in town's ass, and they were after him and stuff. And I've sat through 4 hours of those by the way, I loved it. It was fun. The fucking guys at my dealership, they came in, they go, "What'd you fucking do now, bro?" What do you mean, what did I do now? I'm the fucking business of the year winner. So the FBI's here. And it's like just on TV. I go out in the fucking lobby and I open the door and there's this little fucking silver Impala with blacked out windows and two motherfuckers get out 6'5" and they got suits on.
6'5"?
Oh, dude, yeah. There's the most beautiful fucking Adonis looking creatures just like on TV. And they walk through my door, and me being the fucking clown that I am, they show me the badges. One of them's Indiana State Police Special Investigations. The other one's FBI. And I said, okay, which one of you's good cop and which one of you's bad cop? And they said, Mr. Kimbrough, why don't we go in the office over here? And then they proceeded to grill me about my relationship with the mayor and, had he ever offered me anything and blah, 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 blah. So that's real, by the way, and if you sit through it for 4 hours, I'm talking like I am now and spilling beans on anything that I had, which wasn't much anything. But that's fun. I mean, to me, that kind of shit's fun because, one, I'm sitting there and I know I haven't fucking done anything. I'm not on Jeffrey Epstein's list. I promise you. I haven't done anything that, being at the highest level and ranks in my community is going to bring dishonor on the family and stuff. So
Just win a few lawsuits by giving a couple of hand signals. That's all.
yeah, that's it. Put
That's
a
the only
couple
thing.
signals on the fucking thing. I did do some crazy shit for a while, bro. I'm not above admitting this. I found this from some chick fucking posted this, and I thought it was the coolest idea in the world. I'd go in and I'd fucking take some of my favorite Bible verses and I'd put them in there, fucking paste them in the bottom of the fucking thing, the filing, whatever it was, and then I would fucking white it out so you couldn't see it. And I'm like, I'm sending a fucking God missile in this motherfucker. And then I thought, dude, I don't know if that's smart because they're using AI just like we are. And it's starting to reference shit that it's in there talking about Luke 11:45-52. And they're like, where's that at? I don't see that anywhere. And then they see I'm fucking sneaking fucking. I'm like, this is the most beautiful shit in the world. I'm putting
subliminal messages. You will approve this motion.
Jesus,
it's like
you,
in the back.
So do I. And it's like, I'm putting these biblical verses in this motherfucker and sending it in. And I'm thinking, dude, if they're running it through AI, like I know they're doing, they're picking, where's this fucking Luke reference at? I don't see it in here. And now I'm fucking getting kicked in the nuts because I'm putting some kind of crazy filing in there. They'll do anything if they think they can. So I stopped doing that, by the way. I thought, I don't know if that's the smartest thing in the world, get my shit tossed out.
Hypnotized everybody.
Because I'm putting subliminal messages in my fucking filings,
That's hilarious. Oh my God.
Oh, dude. Well, let me share some of this stuff, dude.
Yeah.
I got some sauce in this fucker, man, and I think it's gonna help a lot of people if they'll just kind of follow.
Well, especially if it's got some hypnotism and brainwashing maybe in there, maybe a little bit.
Probably a lot of that.
Any symbolism we can latch onto?
It's, you know, here's where I told you the first thing that you could take is a lie or not. It's not. So anything in Indiana, you can get in, and any of these filings you can click on and it'll show you the docket. That's the most beautiful thing in the world. This just happens to be one you cannot because this fucking attorney from
Because of the symbols.
Ohio, he filed it in camera, and so therefore it's confidential. So I
In
have,
camera? What did you say? In camera?
yeah, that's the legalese called in camera. If you file it
In
in,
camera means private.
that does,
I
yes.
thought I thought private was only supposed to be used if there's like child medical data or like social security numbers.
It should be. And that was my whole rant about this fucking
I see.
Amish cow milking motherfucker from Milford, Ohio here coming into my state acting crazy. I want everybody to see everything. So he filed the notice of the foreign judgment, the notice of the mailing to my home, and the affidavit of last known address. You'll see that was in February of 25. There was no more activity until I jumped in there, you know, with spears and stuff drawn. So here is the filings. I created this. I sent this to you too, Brandon, as a Dropbox folder of all this stuff. But I went ahead and pulled every one of these documents so you can see exactly what's being filed. I think that's important. This is them sending over, and here's Robert Hingy, you know, what is this? Notice of mailing that he filed into the case saying, hey, you know, I filed this at Kimberly Drive, his dealership, and his home address, and blah, blah, blah. So all of those filings are in this. Here's the affidavit. This is one that I really wanted to focus in on, affidavit of last known address. Now comes Robert Hingay, Esquire, being first duly sworn, and for his affidavit. That's the thing I was saying earlier. And the statute, as you'll see here later, says that the party must. And you think maybe I'm being a little anal there.
Doesn't
No,
that violate
eh,
witness or advocacy rules of professional conduct?
it would, because he's not a firsthand, he just has no firsthand knowledge altogether, and he can't be a witness. And yeah, I could go down that path and raise
It's also hearsay, right? Would be the
yeah,
right
it's
term.
absolutely hearsay as well.
Okay.
So um, you'll see that Uncle Joey filed a notice of appearance in October because I think that's terribly important. I almost filed in and I thought, oh shit, if I don't file an appearance, I'm following down the same path these fuckers are. So I want to be crystal clear, and I know what the rules and stuff say. And then contemporaneously with that, I filed the motion to strike and motion to dismiss as well. And then bang, that's when they scheduled the hearing. You know, so that all was with me. And here's what the rules say about the appearance. And this is me telling you from your state's rules. You should be looking at these things, but it clearly says at the time an action is commenced, the attorney or the initiating party or the party, if not represented by, shall file with the clerk of the court an appearance, setting forth these things. There's times, dude, that I don't even care about the shall part. They've left off their name, their address, their email, or something, and I'm gonna fucking crack them for it, bro.
Mm-hmm.
So, I mean, I think that's terribly important. Now you get down to the section B of that rule, then now it's me. You know, I should file an appearance in there as well, which I did, by the way. So I'm clean in that regard. Um, Here's the local Howard County rules of the same thing. So that's why I was saying earlier, Brandon, it's like, look at your state rules, but also look at Howard County or whatever county you're in's local rules. And this is the same fucking rule. So now I'm taking it to a different level of showing his transgressions. Because here it's showing a whole bunch of fucking shall, you know, with the clerk, it shall be in compliance with the Supreme Court rules. That's where you get them. A copy must be served on counsel or the parties. The clerk shall note the. So there's so many fucking shalls and must. I've forgotten, you know, lost in the. So I'm really standing on that and jumping up and down about it. Here's the Indiana statutory, the statute that I was talking about, the requirements of the affidavit. At the time, so look at your statute, and this is the one I reference. At the time of the filing of a foreign judgment, the judgment creditor.
Real quick, foreign judgment would be defined as a judgment from another state
Yeah, exactly. Yep.
or the District of Columbia.
Coming to a sister state, which California is a state, Indiana is a state. So he's
Yeah.
bringing what's already been awarded out there. So we're not. The irony here is we're not even fighting about the merits of the case. The merits are not. I mean, that's not. It's kind of moot at this point.
It's just collecting a judgment from elsewhere, but collecting it in a different jurisdiction.
He's trying to get it, and I can't remember the word, but yes, he's trying to get it recognized by the state of Indiana so he can start the collection process. So, but the important thing here that I was getting at is that foreign judgment, the judgment creditor, not fucking the Esquire, filing a foreign judgment under this chapter must so the creditor must file an affidavit with the clerk, not the fucking clown attorney that milks cows over in Ohio.
Makes sense.
So you just got to have that procedural set of eyes to look at these things. So right now you've seen that I've already got him on appearance. I've already got him statutorily fucked. And now I take those things and I bring it over here into my motions.
I want to say one thing real quick before we continue. I know for a lot of people, and it was for me, this can be very overwhelming because it's like we're basically saying that you have to know everything under the sun, moon, and stars before you go, and that's not really what Joey's saying. What Joey's saying, just to translate in English, because I'm very good at translating everything into English. I'm not saying you're not speaking English. I'm just saying I know my audience really well, and I know how to translate everything into their ears, and What Joey is saying is that you will develop these little nuances and know all these little tips and tricks if you just continue to file in everything as best you can. Don't stress yourself out too much. You'll get orders back. You'll get things back. You'll learn all this stuff kind of as you go, even if you're not digging for it. I mean, it's good to dig for things, and you can use AI. But like the first time you file some of these motions, you might not know any of this, but you'll learn it and you'll be like, oh shit, okay, I can use all this next time. And then you'll learn shit during that. And then you'll say, oh shit, I can use all this next time. It's a building process. So I just wanted to mention that kind of in passing as you're speaking.
No, I think that's super important. And one thing that'll help you with that is, dude, if you know me long enough, and in teaching in the cohorts, I'm anal about fucking folders. So you'll see that I have folders for everything and everything by date when I'm creating stuff, because here's what I found from experience speaking here is I'll go try to fucking find filings and stuff and I can't find them, but I have folders now for United Auto Credit, and I actually have it by 2025, 2026, and then I'll actually go by the date that I created stuff. So I can go look at the docket, see where stuff's at, and then have a ballpark of where I can find stuff. And that's terribly important when you're talking about volume and building on stuff. But you might have heard me earlier, and Brandon going back and forth, and I was saying that I'm really crazy about this 12F. And that's exactly what I'm doing here, or Rule 12, prior to me answering anything. So I'm not talking about the merits of their fucking foreign judgment here. Whatever. You think you got it, and that's great. And I don't even have to argue that. Before I would argue that, this is what Rule 12 tells me I have to do. Now, I'm filing a motion to strike. That's what that is. And a motion to dismiss. That 41E is the failure to prosecute that I talk. And I won't go through the entirety of it, but I point out the 244 days since they're filing. I didn't add that. I had AI help me with that. That's me uploading documents and having conversational back and forth to create this stuff, but giving them the legal framework of why, and here's that statute that I was talking about, and what they must file an affidavit, not their freaking clown attorney. The local rules and the state rules on the appearance stuff. And so 41E says you got 60 days. If 60 days haven't, the court must hold a hearing, and that's what you're seeing now on the docket. They are holding a hearing to find out what the fuck. Now, I'm not saying he couldn't have got past this, the attorney that is. He didn't do a very good job to say, here's why I've more than 4x'd So you got to come in with a real strong, here's excusable neglect. And what he did, I'll share it with you. Oh, well, the back office got caught up in this, and just trying to have the judge crack anything, and it just didn't work. And now I'm giving a little bit of fucking case law that I found that's supportive of what I'm talking about. Now, if you're using AI, here's another disclaimer. Please check these to make sure these are
Oh
real
yeah, I
because
check them.
it'll fucking
I'll check them multiple times. I'm so
I do
fucking
too.
anal because they are coming down on
Yeah.
these people. They're coming down on bar cards
Oh yeah.
to the point of practical death at this point.
Yeah, I've got one case that I actually saved to my dash or my desktop, and it's one in my court in Indianapolis, the Southern District, and they cracked one fucking attorney for 3 briefs he filed for 5,000 of crack, so 15 grand he had to pay. So, yeah, it's very real. They're going to get them right now, and then they're going to come after you and I thereafter. So, we
And just
have
to
this
be
here.
and just to be clear, I think
Yeah.
that's just to be very very clear on that because that could very quickly dip into Freemasonry and blood drinking and everything else. I actually think that's exactly how it should be. In fact,
Well, I agree.
if I was the judge and I had a pro se litigant, I would give him one warning. One.
Mm-hmm.
And if I see this shit one more fucking time, it's 10 grand per single instance.
Mm-hmm.
If I see 5 instances in one document, 50 grand. Not like it fucking matters. You can just negotiate it and fucking give it back to me. If you know how to do that, fine, that'll work. But I would seriously come down on that shit because that's literally like the destruction of the entire legal system in like 10 seconds. If they allowed that to get out of hand, the whole court system's cooked in about a month. We're done.
Agreed.
So, and you got to think all the work of John Marshall, all the work of Roger B. Taney, all the work of Samuel Freeman Miller, all the work of Ward Hunt, all the work of all these people for hundreds and hundreds of years is all flushed down the toilet in a matter of 30 days because fucking computers are a bunch of fucking retarded computers and people aren't. So it's a big deal that deserves a strong arm. And I think the courts are just slow to even realize how crazy this is getting. It's kind of snuck up on them over the last couple of years, and then now it's whoosh, and I think now it's all in their face real badly. So I think that's also kind of why they're having a strong reaction to it, which I think their reaction's been kind of slow. I think they should have started bringing the hammer down on that shit earlier. They're bringing the hammer down now on opposing counsel as well. Have you seen that?
Yep. Yep.
So they're
I
saying,
sure have.
why didn't you catch this too?
Well, they should. Yeah, they have a responsibility to do that, and I've done
Yeah.
that in some of my recent cases. Is that you being a bar card, you're at a higher ethical standard, or you should be. If you see one of your peers
Yeah.
doing it, you should be calling the Supreme Court, judiciary. So. Yeah, so what happened with that motion, like I said, it went for a hearing. So they scheduled it for November 4th at 9:30. That's beautiful. I get excited. I actually took a shower that day, combed my hair, whatever I did, brushed my teeth. So it was noticed to us that this is happening, it's coming, and here this dumb fucker files a motion to attend virtually. He didn't want to leave his cows over in Ohio to come to Indiana. So he filed this motion. I don't blame him. I wouldn't want to come to Indiana and all of that stuff either if I'm over there milking cows. But immediately the judge granted it. There's a whole other issue. Now, if I were teaching this, I would ask you what the fuck the issue is. The issue is that if you haven't even filed a fucking appearance, you can't be coming and attending virtually. That was my whole thing.
That's a good
And
point.
you'll hear me all the time. If an attorney does something wrong, respond in opposition. If a court does something wrong, fucking object. So he granted that immediately because it's his boy, and that's okay, and I ain't mad about it. But I filed the fucking objection, and you'll see that later that his fucking appearance got vacated because yours truly is the one that wrote the proposed order. But I wrote everything that I had built in there previously, and you'll see that here. You should see that here. Yeah, right here it is. Here's my objection. Short and sweet. It wasn't anything big, but it was basically I'm saying how in the fuck it's non-compliant. You haven't even basically filed a fucking appearance. So I give him a backlog and all of that. Violation of 3-1 and the local rule. It mandates that he must have an appearance on the record. He still hadn't fucking filed an appearance, and you're letting him come in here and appear virtually when he's not even appeared before the court. They're not here, is what I'm saying. There's no jurisdiction right here. So I just kind of got on a 3-pager. I'm not going batshit nuts here, but you need to vacate this order. You need to strike all of his horse shit that he's got there. So I'm crazy about creating that record, and that's what I did here. Now, what did they do? They fucking ignored me. And that's okay. I don't care because later on,
Aren't they by procedure supposed to treat that as a motion to reconsider?
they should actually grab that objection as a motion to reconsider. And I clearly outline what he's doing wrong. But what most people have heartache with, Brandon, and rightfully so, is they ignored me here too. But I didn't really care. I'm going to keep on moving down the road. If he doesn't want to play ball, that's okay. We're going to talk about it at the hearing too. I know that's coming up, and I've preserved my right to raise hell at the next level if I need to. So I'm cool with that. You do you, I'll do me, and we'll be fine, Your Honor. So it's saying, hey, the defendant's filed his objection, blah, 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 and they're going to set that matter for the same hearing. So that's cool. Let's talk about that there too. And so I'm happy with that. No big deal. I've got it preserved. We're going to talk about it at the hearing. So here I raised hell about, and this is something you'll appreciate, is I said there's a notice of material inaccuracy in the court docket and a motion to correct the record. Now I'm getting anal with the fucking clerk, and I'll show you why. This is going to be funny. So for me, it's not, though. Proposed order granting. Here it is. But I'll give you kind of the exhibit A. This is where I go batshit nuts when I'm going into research mode.
This is new. So just so everyone is tracking, this is brand new. This is something brand new that Joey has done. This is beyond my own understanding. I know a lot of people are going to be very interested in this. So if anyone is watching this kind of in the background, you may want to stop whatever you're doing just for this part, at least, because this is something that I think a lot of people are trying to figure out. Just as a quick side note on this.
Well, this is different from this is not filing.
This is your mandamus, right?
This is not yet. It's coming up. But this
Okay.
this is a clerical thing because this is the judge that was presiding. His name is Matt Elkin. I know him. He got fucking not disbarred, but he got fucking and I kind of in that video I sent you, I get a little bit more because you're calling him honorable and the fucker's not, and I want to show you. The Honorable Matthew J. Elkin shall be permanently banned from judicial service. The motherfucker's got kicked out of the judiciary because he was trying to milk gals or whatever he was doing in this fucking jail program. He's talking down to people. He's doing stupid shit, and they finally got some complaints, and somebody did something. Good for them. But the thing I'm raising the hell about here, Brandon, is they're fucking showing him as still the presiding fucking judge that's going to show up in November when I know he's not. And I've got the Supreme Court order showing he's been fucking kicked out as a judge. He's not a fucking judge. Quit calling him honorable and shit like that. So I'm getting a little anal about that. But here's the other exhibit that I showed because I got to show these guys how stupid they are. I highlight everything. And here it is.
You're like literally my worst nightmare.
I'm their worst nightmare, bro.
If my worst nightmare is me suing you and you being the defendant and pulling all this shit. I mean, I'm kind of over it at this point. Like I've already gone through 2 years of literally wanting to do horrible things. Not literally, but like just now. I just, whatever anybody says, I just yawn, I fix it, and then I try again. And then they bring up some more horse shit. Like, if you brought up horse shit about appearance, I would just be like, yep, you're right. Here's your appearance. And I would just resubmit everything. And then you would say, this is spelled incorrectly. I'd say, no problem. He's right. Exactly. It's spelled incorrectly. I would fix it. I would refile it. You'd say, oh, you can't, you didn't the date's incorrect. I'm like, oh, he's right. Okay, fix the date, resubmit it. Like that's just
Yes.
kind of where I'm at because I don't
Bro,
know. I don't
that's
know what
it.
else to do, and it's the emotional upset that destroys your case.
Yeah.
And I was like, if I just say fine and just accept everything, little bullshit things like this that they do, which is their fucking MO, you kind of take away all their power.
You do.
Like the way I
And
would
you're
take away power from you is I wouldn't ignore any of your shit. I'd be like, you know what? He's exactly right. Here's everything fixed. If you look in my City of Glendale case, when I got the demur, everything on there that I thought had any merit at all whatsoever, I was just like, yeah, he's right. And I attached it, whatever he was asking for. And
you know,
that's
and
kind of what I'm going to start doing. I'm just going to start
well,
doing that.
that's exactly what's supposed to happen, bro. And you and I have taken the ego out of the equation there. They haven't, unfortunately.
Yeah.
And it's to their, demise. Because yeah, all the I've got all the rules. And by the way, if you saw that, I'm killing the fucking clerk and telling her what her rules are and how she must make the changes. Now I'll let you guess, and we can log in and look at that. Well, we'll see it. None of this has been changed, by the way. But I've said, in that order that he signs, that it should be. And here's that. I mean, and we won't have to go through it. I don't want to go through everything. I mean, if somebody wants to see this stuff, they're more than welcome to. But here's the inaccuracy.
To log into these cases and download the items, it's free, right?
Free, 100% free. This
That's
one,
important.
like I
This
said,
is not Pacer, guys. This is state
yeah,
state cases.
yep.
And Indiana is super cool. Do you need a login to get into these cases, or can you get into?
You'll have to set up an account, but that's free also, and it's
Okay,
super
good.
easy to do. They
This is
mail
great.
you a fucking PIN number, and then you log in with that PIN number, and boom, you've got an account. So
Great.
it's super easy to do. But this one, unfortunately, that shitbag having filed it in camera, that's why I'm showing you these I went because I had filed all of them. I have access. I created a Dropbox folder if anybody wants to see them. But yeah, I think there's some good gold in here, obviously. But it's super simple. These are easy 3-page fucking, you saw the exhibit A and B already that I referenced in there. But these things are slowly fucking killing these guys. That notice of inaccuracy is very real. And if you allow that to come on, you lose the fucking jurisdiction of the court if you're fucking saying Matt Elkins is going to be there presiding when literally the Supreme Court said he can't. He's been removed September 30th, and you're saying November 4th he's going to be at a fucking hearing. Sorry. So they're getting all of this stuff here too, and here it is. That's that one I was referring to. So he literally was removed September 30th. He is not a judge anymore, and they're saying he's going to preside it. Now, that might sound very anal to some people, but that's the level I go. It's like, how can this motherfucker be there when he's been fucking not disbarred, but removed from the bench? So anyway, we have the hearing on November 4th. We do our fucking pomp and circumstance, and the judge says, you know what, we're going to take everything under advisement. Where the fuck is that? Next, first class mail returned. Hearing, here it is. Commenced and concluded. And I think and here the interesting thing is, on the same fucking day, the guy finally files an appearance. There it is. Okay, bro, I'm done with that one now. But everything prior to this is fucked. You got to throw all of it out too if you're following. Plaintiff appears by counsel.
If he if he files an appearance that late and it makes his previous filings essentially moot or
Moot, yep.
strikeable, does that now mean that he's passed all of his deadlines for all of his previous filings and he can't really even refile them? Is that kind of where you're going to go? You're going to go that anal on it?
I probably would not attack it because I had so many other things that were going in my favor that. Yeah,
I feel like okay. Let's talk about this for a minute. So sometimes I'll go back and forth with AI, and AI will say things like, if you do that kind of stuff, it'll kind of give you like it'll give you like a bad, like the judge will kind
bad
of
faith kind of thing.
Negatively, like
Yeah.
it, like I started getting with AI and I was like, talking about it being a day late and all this kind of stuff, and it's like, well, in reality, in your jurisdiction, it almost never flies that a motion to compel discovery that's 1 day late actually gets approved. It's just not. It's just not. So it's sort of like, and AI was like, and if you try to pull that kind of stuff, it's just going to look like you. It's not going to go over well, basically, right? And it's an interesting conversation to have, because before we got on here, I wasn't going to file objections, but we were talking, and now I'm kind of thinking about filing some objections. It's sort of like the objections I'm going to file is like, look, I've been to 2 hearings with this judge, and he's an extremely amazing, friendly, caring judge, and it wasn't just me that he was giving this extra time to. In fact, he gave extra time to practically anyone who needed it. I'm sheerly and explicitly making this objection just entirely mechanical, based off of procedural aspects, to make sure that I have access to the appeals courts, not on any meritorial basis whatsoever. I don't know how else to really write it, because if I was the judge, I'd probably do a lot of the same shit he's doing. It's just, but at the same time, I also want to make sure that I can preserve my right for appeal. So it's just kind of like, how do you meet somewhere in the middle without looking like a fucking retard psychopath sob sit? A lot of the sob sittery revolves around that too. So for example, I'm in these 2 hearings recently. I haven't really had any hearings, and I'm seeing these bar cards on the vid feed, because I'm like the only guy that ever shows up in person, right? And I think the judge really appreciates that, by the way. It's an interesting, you can just tell the way he treats me. He really appreciates when people actually fucking come into the court rather than sitting their lazy ass at home, probably not even wearing any pants below the fucking camera. And he says, to many of the lawyers, he's like, I remember one time he was talking to one of the lawyers, he's like, lawyers always ask for less than what they need. What is it that you really need? And he said that to one of the lawyers, and the lawyer, I need 2 weeks, Your Honor. If I could just get 2 weeks. Okay, well, why'd you say 5 days? And the attorney was all flustered and this and that. And almost every attorney was very flustered. And he kept trying to correct them. He kept trying to get them to talk. They wouldn't really talk. He's like, lawyers don't say enough. They don't talk. You need to talk. I don't know what you want. I don't know what you need.
I agree.
He said multiple times, all lawyers are scared to ask for anything from judges. He said that several times. And I'm sitting there and it's like, wow, this is a hell of an experience, because, you've just been hearing online in the echo chambers that they're drinking blood out of a chalice, and where's the dead babies? That's kind of what we're looking for. You know what I mean? So it's just interesting when you get in there. I'm not saying all judges are like this. I'm just saying it's just interesting when you get in there and you start looking around and you start seeing that these bar cards who have been in front of this judge many, many times, they're maybe not as nervous as you are, but I'll tell you what, by the second time I was in there, most of the bar cards that were on the video feed that had been in there many, many times, and they're on a fucking video feed, were more nervous than I was the second time walking in there in person.
They've got more to lose than you've got to lose. There's the ego involved in the whole bit. So it's
very, and I talked to a lot of people who come to my hearings and stuff, and they're all shocked. Everyone was shocked. Everyone was shocked. Where's the dead babies? I mean, not literally, but I mean, kind of literally. Like, a lot of people in the sovereignty space, they expect, craziness. And you go in there and it's really depressing is what it is. That's really what it is.
I've equated it, Brandon, to, people give attorneys way too much power and create way too much anxiety in talking to them. I've equated this to every one of those motherfuckers were the ones that I bullied in high school. And I'm the first one now telling you I apologize for doing that, flicking your fucking ears and tossing your tray in the food line, all that shit. You were the ones that got picked on, and now you're wanting to take it out on me. I apologize. Please don't do it to everybody else. It's like they've been picked on. They're jumping off fucking buildings at record rates. The suicide
and the alcoholism. If you go on the Reddits, the Ask Lawyers Reddits, where it's all, you actually have to be an attorney to even get into those Reddits. But what's cool is you can read them You just can't comment. You can read everything they're saying, but I believe you have to actually be a licensed attorney to actually comment in there. You go in there and read the amount of substance abuse posts and depression posts
Mm,
and suicidal thought posts. It's literally just public.
yeah. Well, we had a hearing on this date. Here's what we talked about. The stuff that I was remember who's driving here too. And if there's anything I can say to you guys is the confidence that you have in what you've built before, you take that into the hearing and you just that's all you're talking about, by the way. I'm not talking about any of their stuff, but you'll see the evidence was heard and the matter was taken under advisement. That's what they always say to get the fuck away from you. And on the record, if I showed you the transcript, he said you'll have a ruling by the end of the week. But here's another important thing. Matt Elkin was not there, but it shows that he was. You know, that's a huge issue too, by the way. You're telling me that you're going to let a suspended fucking judge preside. That's what the record's showing, and the record has to be accurate, and that's what I keep jumping up and down a bit. So you can see here the 30 fucking days to the day. I probably should have waited one or two. I'm better than this, but on the 30th day, because Indiana Trial Rule 53(1)(e) tells you the process for sending this to the chief administrative officer, I filed a praecipe for the withdrawal from this fucking clown. He said he was going to have an order by the end of the week. He didn't, and and I'll show you what that looks like too, which I think that's here it is. This is what I filed with the court, and I'm withdrawing this from you, shitbag, for these reasons. And here are the reasons, and I won't go through them. But it's not Soft City. It's all fucking facts of everything that we just talked through. And you're gonna fucking send a copy of this and the record to the chief administrative officer of the Indiana Supreme Court. So, as will happen, and this is what understandably some of you guys get so fucking worked up about, and I get it, they'll ignore you there. The clerk, I just gave her a price to pay. If you look it up, is a writ. A writ is a fucking command. I commanded this bitch to fucking send my stuff to the Supreme Court. Please do so. Now, they know me too, and there's some clownery there. But look what I did again. The wheels of justice don't move fast, and people assume they do. I waited another 6 fucking weeks. And then I fucking created my motion to compel the bitch to send this thing. So he had to sign it. So I gave him a proposed order with that motion. And here I'm actually attaching what 53(1) says. And so you'll find that you don't have to be the smartest person. And when you're talking to AI, it'll help you. But you've got to train these fuckers. It's crazy. They'll play stupid. And honestly, I think some of them really are stupid. So the ones that I've interacted with. But here's the motion to compel. Here's everything from a history standpoint. Here's what I'm telling you need to do, Judge. And you're going to fucking do it. Here it is, certified January 14th. It's been filed. Here's the proposed order. This is going to be the cool thing. At the end, you'll get to see some stuff that I create and then they sign. So here's the order granting. I make it so easy for him to sign the fucking thing and send it. And you'll see what happens here. He has to. He knows he's fucked. Motion to compel, order granting. There it is. So, he has to at some point. Now, if you look at this, and this is not me being arrogant, but this gives you a dopamine hit. I don't care who you are, if you're a defendant. I created this. You fucking saw it over there in my words, and look what the fuck he had to sign what I fucking created. Word for word, I created this fucking thing. Oh, by the way, send me a copy to my house too, bro. So, that's, dude, when you're in this space and you get a judge to sign something that you've created when you're kind of rubbing his nose in the carpet, if you will, they will. So his order, and I can't see this, but this is one of the clerks, and here's an affidavit saying I sent everything to the Supreme Court. Well, look at the timing from the time he sent the order on January 15th to the time that we received a response back from the Supreme Court. What, almost 3 fucking months? So it's just the way things move, man. You're not gonna, but this is super important. This came from the Chow. Supreme Court, pursuant to 53(1), a matter judge is warranted. Review of the certified reveals that February 14th filed a notice, blah, blah. He just goes through the whole fucking thing here. On December 4th, Joey Kimbrough filed a praecipe with the court. In this praecipe, petitioner accused the court. Okay, cool. You paint me to be an asshole. That's all right. I don't care. I'll accuse you of anything. Of failing to timely rule. He's got the dates wrong, but that's all right. A couple other things. 53(1)A requires a court to rule on a motion not later than 30 days after its filing. CCS does not reflect the issuance of an order concerning the petitioner's November 1st motion. So the 30-day time frame is mandated by the rule. The court's failure to timely rule on December 1st constitute a per se violation of 53(1). The praecipe is granted. Thank you. Signed from the Supreme Court of Indiana.
That's cool.
Oh, it's super cool, bro. So when that missile comes back in here, and the reason why the judges don't like this is there is now work that they have to fucking do. Because here's another one right here. So now you're getting something from the fucking Chief Justice, my girl, Loretta Rush. He's to file a fucking report pursuant to 53(1)F. And he hates that because now he has to fucking outline every fucking thing that he did wrong and why he didn't keep this thing moving forward. So Chief Justice Rush,
that's sort of like the corrective action.
It is. It's
so
not
like
an
you're saying
admonishment.
something's wrong, and then this is sort of like a corrective action to like dig into it more and to ensure it doesn't happen again. So it's sort of like, that's smart.
They said in that too that they're doing Special Judge Josh McMahon. Dude, look at this. The 24th, 23rd. I knew this as soon as I saw it. By the way, I know Josh McMahon. He's the one that created my mother-in-law and the aunt's fucking trust documents. He's also a Howard County prosecuting attorney. He knows me very well is what I'm getting at. So I knew he was going to recuse. Boom, he recused like fucking one day after, and it went to Steve Kitts. I know that fucker too.
So he got randomly chosen. He knew that he had too much bias, knowing
and I'm
you
glad
as well.
he did. I wanted him to do that. I don't want him staying in there and then UACC saying, oh, well, they had a relationship. They know each other and blah, blah, blah. Fuck, thank you, Josh, for doing that, bro. So here we go. This is where it's kind of, getting interesting. The special judge assumed the jurisdiction. Okay, cool. Here we go. Oh, by the way, guys, you can counsel. You're directed to call Dana Kelly. Well, what about me, you fuck? To schedule hearings with special judge, or you can email the fucking whore. Whatever. I'm not interested. You'll see what I did here. Defendant's motion to renew and bring forward all outstanding and unresolved motions before the court, bro. I'm not interested in playing footsie with whatever the fuck her name is. I'm interested in getting my fucking relief that I asked for. You just saw me fire a missile. You saw.
So you're
the Supreme
saying
Court.
Everything before all this goofiness is still sitting there.
Yes.
Just you come in now. You've got a table to clear. Just clear the table. That's
Clear
what
the
you're
table,
saying,
bro. And I'm going to help you, bro. Okay. So here's what I did. There's the orders. Here it is. This is going to be. This gets me excited. So I filed this. I don't even know if this is real.
Is this why they always refer to everything as the court? The court believes, the court orders, because it allows you to shift out people. And it's like the court itself is like a static. Like you could shift out judges every other day, but they're still like the court. Is that why they talk like that?
They're separate, and that is a great point. So a judicial officer is separate from the court altogether. To be real honest and not to sound fucking goofy, and you're going to see that, I'm the one writing the fucking orders here for what I want to have done. I'm the fucking court. If I don't want that to sound arrogant, but you are the fucking court. I'm the court. They're
no,
just
the judge that I have in my City of Glendale case told me that. I went up in front of him the first time, and I said, thank you very much for having me in your court. I really appreciate it. He goes, this isn't my court. This is your court.
Amen, brother.
And I was like, damn, okay, cool. I was like, that's right. Cool. I wasn't expecting that. That was a cool little experience.
Though. He knows that. He knows his place in there. And I'm not arrogant about that. I'm really not an asshole to these guys. I know they're a trier of facts in law, period. That's the only they're a referee. But a lot of people give them a lot more latitude than what they should be, and they fear him and all of this other
Well,
shit.
the bar cards, really. I mean,
Well, they need to
every
because they're under
every
the thumb.
single bar card in there. I was sitting in there, and everyone we packed the whole auditorium the first time, and then the second hearing there was only a few people that came to see it because the hearing was iffy if it was even going to happen. But the first hearing was packed. I don't think there was a single chair that wasn't filled, and everyone in the hallway was blown away. They all thought that it was just very different than anything they were expecting. They thought that the judge was so kind. They thought he was so understanding. They thought the bar cards were weird. You know, it was a very interesting.
It would have been a different outcome, bro, and you know this by now, and we laugh about this off the fucking camera. If you would have went in there maybe 2 years ago with your mindset you had, it probably would have been a little different. Or if
Screaming about pirates, maritime, something.
I am a free man, blood flowing through my veins.
I would have said non-citizen national. I would have said non-citizen. 2 years ago, 3 years ago, I would have said non-citizen national.
He would have said, "Get the fuck out of this."
That's what I would have said.
Bro.
Yeah.
You know, but now you're actually,
funny.
you go in there clean cut, you got your nails done, whatever you guys do out there, and
it's
you're
June,
respectful.
Man. Pride, man.
But
I actually wear my tranny flag when I go in there just to make sure. Just to make sure.
You and Carl are gonna have those. Oh shit! But I filed
eating a banana like this, in the courtroom. You know what I'm saying?
Oh, if you do that, you got all, dude. They're gonna come after you, bro. Be like a magnet.
I'm hungry, Your Honor.
I love the way you handle that banana, bro. Oh shit, clowns.
Oh my god.
But I created this for the dude, just giving him an outline of what's unresolved and what, it's just super professional. I'm not asking for fucking everything. And again, it's only 5 pages, so I gave him this. And the important thing is I also
that was to the new judge.
The new judge, the one that just assumed jurisdiction. Absolutely. Here is the killer. And there are some things that I know there are people listening to this that are going to disagree with me. And this one right here is it. I know there are some people, probably even you, Brandon, like,
no. I get it. Now I get it.
We were talking about this earlier.
Everything. So that's another thing. So everyone wants everything dismissed with prejudice. It's like you're screaming it, ripping the fucking camera out of the desk, right? Mm-hmm. Or the microphone when you're in there, ripping it out, fucking with prejudice, right? First and foremost, it's considered a more extreme label.
Yep.
With prejudice. With prejudice is like fraud, like crazy shit, like bad faith, like fucked up shit, like extreme neglect.
Mm-hmm.
These are things. Without prejudice is almost a little bit more biting. It's almost like without prejudice. Oh, but hey, bitch, if you want to come back, you're more than welcome. Here's the other thing. I have seen 80 million things dismissed without prejudice. They are never, ever, ever brought back. Ever.
Oh, no.
Ever.
These guys won't come back.
It would need to be like a criminal thing where you're doing some kind of horrible criminal act. And if there was like a mistrial on that and like the public went fucking ballistic and they're like outside the fucking courthouse, that's the kind of stuff where they're going to come back and then they're going to come back again and then they're going to come back again and you're cooked basically because you did something really fucked up.
Yep.
And everyone's pissed off about it and you just aren't going to survive it. There's just no fucking way basically, unless you're O.J. Simpson essentially, right?
The glove didn't fit.
Unless the glove didn't fit and you're on a racist wave and there's just massive amounts of racism and you're able to get whatever his name is, Cochran or whoever it is, to spin the whole case into a
Robert
fucking
Shapiro,
racial thing, and he can work the media. And I mean, the guy is a brilliant. He's brilliant. He was able to just deflect everything into racism and PR. Kind of brilliant in a sick way, right? But if it's not something like that, you might as well just write without prejudice, but it's basically with prejudice. Just think of it as with prejudice.
Yeah, so you know, talking about the dopamine hit and getting the order signed and stuff, this is kind of the finality. And I've had a couple of these, and this is, you know, so I'm telling him everything I want, but I'm telling him everything I've built up to this point that gives him the ability to be able to do it, right? The foreign judgment's got to be stricken, bro, because it was horseshit and it was defective. Dismissed without prejudice, you know, pursuant to the 41E because they failed to prosecute, and then the statutory part about the, you know, the not filing a fucking appearance, you know, and then vacating the virtual appearance. I even went so far as saying you weren't even fucking there, bro. We vacated the fact that you were even fucking there, you know, so that's got to be done.
Did
And then
was he there, and then you trying to vacate it after the fact?
he was there. We had the whole hearing of
So
October
you're
20th.
trying to strike the whole hearing,
Yeah,
basically.
he wasn't even there. It's vacated, and you'll see it here in a minute, and you'll get really excited. Now, here's a killer right here. All proceedings, and this is what most people that reach out to me want, is to stop. Fucking please, just make the stuff stop. Okay, here it is. All proceedings or enforcement actions related to this dumb shit is stayed unless and until the plaintiff complies fully with Indiana fucking statutes and appearances and all applicable rules. Be careful with that one. So if you come and try to collect anything off of me, good fucking luck, bro. Because now, you know, in any future refiling, because I'm not saying this arrogantly. I truly deep down hope they fucking come back. I do. I'm waiting, bro. So the clerk.
I would walk away from this shit. I don't walk away from anything, bro. I'm dying on every fucking hill I walk up, bro. And I would walk away from this bullshit. There's
Well,
no fucking way.
here
Oh,
it
you want to
is.
sue Joey Kimbrough? I'm not your
Do it.
guy, bro.
Come on over, man.
I'm not your guy, bro. I'm not your
Looky
guy,
here.
bro.
Look at what happened on May 21st. And this is what I want you to see.
Oh,
And I want you
I'm
guys to
crying.
get excited because, dude, this is like the dopamine hit right here. Every word you just fucking saw, everything I said I wanted, look what he did. He signed it and dated it and says, "Yes, sir, Mr. Kimbrough. I'm glad to be able to do business with you. Thank you so much for being professional. I'm a trier of facts and law, and you're 100% right. All of this stuff is yours. Please, you don't come into my fucking state. It's all stayed. Fuck you." So I even took that, and now this is going to sound even crazier. Is I came over to Letterstream, which is my favorite fucking platform for sending stuff, and I sent him a little letter to UACC. Here it is, and I like to see where they signed for it. So Brad Church signed for it. That was the registered agent, and then I view it. I got to see it. So let's make it a little bigger. So it's from me. Here's my home to them in their place, the registered agent. And here it is, guys. Final and conclusive notice. Court order entered on May 19th. No further correspondence will be issued. And I just kind of go into a very nice cracking their fucking ass and telling them they're stupid.
This is what fucking what's his face did. Fucking Carl did when he got his demur. He sent me this. It wasn't
did he?
like a letter like outlining all of it, but it was just he just
Yeah.
sent me everything through mail. I'm assuming probably to like fuck with me. I don't really know. I don't know if he's had to do that or what.
The
But
finality he's open for, just like I am. So I give him an Exhibit A, and I tell him what the Exhibit A is. Here it is. It's that order we talked about. Just in case your attorney's crying and he's milking cows, I'm sending it to you and saying you didn't do very good, bro. You know? So the fucking letter.
sudden spike in alcoholism and suicide in the legal profession.
Oh, dude.
Already having a second highest only to dentists and doctors. There had been a local investigation by a local nonprofit organization. They found the source to be one Joey Kimbrough of Howard
Oh,
County.
dude. Man, it's just they spent $157. Good, God love them. They came in and they tried what they. But the reason why I'm showing this, and I'm so excited about this, because this is maybe the easiest, clean cut, not a lot of hard work. But there were some procedural steps that you have to do, and they thought I owed them $23,000, whatever it is. I don't care. I don't, and you can fuck off. So it's not hard, and anybody can do this right here. If I can do it, I'm telling you, anybody can do this. It's not terribly hard to get in, but some people never get here because they're so fucking anxious when they get that that summons in the fucking court along. Oh my God, I'm being sued, and it's an attorney. This guy's stupid, and I'm saying that with all the love I can. He's stupid. I hope he watches this. He's dumb. He's not very intelligent, and he came into our courts and he acted a fool. And it took me two judges, bro, and one that had been disbarred, and he removed three. So let's call it three to get it done. But it's not. And I'm not. It sounds arrogant, I know. But dude, any of you guys can do this. This is not hard. You just have to put a small amount of effort. And when you get this right here, and this is, you got to be careful. This fucking dopamine hit right there in that order where you fucking said, here's what you're going to do, and here's what you're going to sign, and the fucker signs it. I'm telling you, man, I'm 25 years into the recovery game on drinking, and this was way better than any of that ever was. I mean, I'm telling you, it
Hell yeah.
just takes things to a whole new level of fucking the game, man. I mean, so, and I do that same thing over on the plaintiff side. Now, there's some stuff that I'm doing here. I mean, we could show them some of the letters, I guess, where I'm starting to file complaints against these guys. And, Brandon and I agree on the plaintiff thing. I think that's the most important thing. It teaches you how to sue people.
If I was in that case, just real quick before
Yeah.
we move on from the case, I'm not in disagreement with anything you're doing. It's just I have a different style, I guess, so to
Sure.
speak. If I got sued, it would just be an immediate issuing of a note. I would have the Williams and Williams heading would be at the top of the note, and it would be a promissory note plus a allonge, something like that would probably be like the heading, and it would start off and it would be like, this note is being issued by sole proprietorship, all caps Brandon Joe Williams, registered trademark, by his owner and representative, Brandon Joe Williams, which is a white Californian, period, space. And then I would say, this note is being issued to, and then I would have the name of the payee, and all rights on the instrument are hereby given, essentially as like a quitclaim deed. Essentially, I hereby forfeit and relinquish all rights on the instrument. This instrument, and then I would do next paragraph. This instrument is payable to bearer. It's also payable on demand, and then I would say this instrument is an unconditional promise to pay, and then whatever the amount of the judgment is. Mm-hmm. And then I'd be like, a copy of this instrument will be filed into case number blah 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 blah. And it will say not non-negotiable across the face of the instrument, and it will have attached the registered mail printout or whatever, because the original will be mailed straight to the payee using registered mail. And then it would be like notice of completed payment would be like the name of the filing that would go into the docket. And I'd file all that in the docket, and I would just go to fucking war. I mean, who knows what would happen, but that's what I would do. That's how I would handle that. And then I have no idea what would happen. I could see the whole case just going cold and there being no filings basically forever. I could see filings getting filed in, this is frivolous and all this kind of stuff, and we would kind of go down that
theory.
path. But that's how I would handle and address the situation.
Yeah, I think the opposing counsel, if you have a retard like I had there that milks cows in Ohio, in Amish country, you're probably pretty good with that, honestly. But if you get some that I've dealt with that actually want to take on and fucking challenge and do the vapor money theory and the SOVSIT stuff, it behooves them to do that too, by the way, as you and I both know, because we know why they're there. They're there for the billables, right? Mm-hmm. They love you, by the way. They want to kiss you on the forehead, come to Glendale and whisper sweet nothings and buy chocolates for you because
come for Juneteenth.
Oh, so I gave them an easy out, smashed them in the nuts, and they made a few bucks. Your route is going to take them, like my Amex case, for instance, that's going on 4.5 years. It's 5 in December it will be. And they've made an ass load of fucking money by me just kicking and fighting, and which I think that would turn out to be, and I think you believe that too.
I'm not 100% sure anymore. I think if I would have done it like a year or two ago, for sure. But now, I don't know. I feel there's sort of a shift happening.
Yeah.
I,
Best
I
case
don't,
scenario for them is like you said maybe a minute ago is just put it on ice. Fuck it. Just let it
honestly,
sit
I'm
there.
seeing a lot of ice right now.
Yeah.
And not just with our stuff. I'm just seeing a lot of stuff getting iced out. So I don't know what is happening. There's something happening. I don't know, but that's like a zeitgeist thing. Because a year ago, you're 100% right. If we would have filed something like that in a year ago, it would have been they would have been looking in the mirror, painting their face, telling their wife they're going off to war, putting their shit in a duffel bag, and they're on the bus. I mean,
Yeah.
no question about it.
Yeah, I think you're 100% right there that yeah, I look for what I want, what I assume is. I gave him the doors half open, but I'm looking for the finality of having that order of dismissal and having the dopamine hit that I'm looking for. And even more important, something you and I talked about, and I almost forgot to say this, is I literally have persuasive authority in Howard County now. You know, I can literally reference back to that case if there are any irregularities or procedural mishaps, 41E, 53-1, you know, any of those things that I referenced, I'm now the persuasive authority for that. If we have that same issue come, you know, if you lived in Howard County, hey, bro, I've got this case you can reference now. If they start fucking trying to drift, it's reference, hey, in Kimbrough v, you know, whatever, or you know, UACC v Kimbrough. And now you have the persuasive authority. It's not case law. A lot of people think it is, and that's great. And it's definitely up the rung. But if you have something in the court that the court can use as persuasive authority, that's beautiful. Outside of your words and talking about what you believe it is, that's real.
Well,
That order is very real.
Once my Amex case in the Ninth Circuit comes back, that could be some real serious case law for the Ninth Circuit, especially
Could
for
be.
my own shit. That could be some real. That would be more than just a missile. That would be a full blown nuke.
Yeah.
But on the flip side, if it comes back, it could nuke me in the face too. I don't think that's even physically possible
No, I
because
don't think so
the
either.
paper's full of so much stuff that there's no way they can turn the whole thing back around on me. It's not put together great. It's not anything anywhere close to as good as the amended complaint that I just filed into the City of Glendale case. But that reply brief was the first brief that I wrote entirely on my own without any help from you at all. Remember that?
Mm-hmm.
And that's also the brief where I created the very, very first version of the vapor money theory and the sovereign citizen rebuttal. So I had the sovereign citizen rebuttal, I had the vapor money theory rebuttal, I had a full step-by-step breakdown rebutting everything. I had a closing argument that was really strong, talking about how everything you're seeing me write about here applies also to all three judges that are on this case. You're all getting fucked just like I am. And if you don't think there's a fucking problem with that, I don't know what else to say. All three of you are getting totally fucked by the same company. If you guys
Right.
have any of these credit cards, every time you use them, there's a promissory note that's being fucking developed. What's happening with these things? Are they being abandoned? Are you donating them? Have you ever had this conversation? There's nothing in the contracts that fucking tell us anything about this. You're getting fucked. I'm getting fucked. It's sort of like hey, we're together, guys. We're all getting fucked together here. It's by far the strongest thing that I had filed. It's probably one of the only filings that's I would consider one of my old filings that is still, in my opinion, pretty strong, and I think that's kind of why it's been iced out.
Yeah,
I
I would
think
agree.
I think August 10th it'll be 1 year iced out.
That's crazy. You know, that may be one of those things you and I can talk about that where you just file in a fucking little
I was going to
note.
call him on the 1 year mark. I was going to literally call the Ninth Circuit
Yeah.
at
Happy
the 1 year
anniversary.
mark. Yeah. No, I'm serious. I was going to,
Yeah.
hey, it's been a year. I'd like to at least, can I get some info on this?
You can nudge them, you know, the notice of, you know, just a quick nudge. Hey, man, just letting you know I'm still here and waiting on a ruling kind of thing. But
Yeah.
yeah, there's there's a lot of crazy stuff that I'm doing. Maybe I can show just a moment of this and talk through kind of some of the stuff we were talking about earlier. I don't want to go into detail on this.
People would like to see the mandamus.
Which one? The one that I created? Well, that's for Steve.
Oh, we'll skip that one then.
Yeah.
No, the one that you did.
The
Didn't you do one?
No, I don't think that I've done.
Was the Precipe? That's it. That's the mandamus.
That's the only thing that I've created.
It's the same thing. Precipe and mandamus is the same thing.
I did. Okay, you know what? I did, and that one got
say.
actually denied.
Oh, okay.
It did. It got denied, and I can show you that, which I wasn't upset. So here's what happened in that one. In this case, is I'm trying to remove this dumb fucker. And it had been like 2 years he hadn't done anything. And here's what the Supreme Court came back in their denial. There's good old Amex. I love them.
Real quick, so anyone can make an account for free, type in your first and last name for free, pull up all your cases for free, and then download each individual docket item for free on all cases. Is that correct?
And right here, this is a great one if you want to get into it. This is me doing battle for fucking 4.5, almost 5 years now against Amex, and there's some really good fucking sauce, and it's getting really heated down there at the end. But this is one where you can literally, like Brandon just said, click on these fucking URLs, hyperlinks, and pull up the fucking every filing in this thing, which is beautiful. So you can see everything. You can go to August of 22 and you can see where this dumb fucker, which I'm raising hell about right now. This is such funny. And if you read through this, dude, I could write a book on this. This guy filed in and he said his cats fucking died is the reason why he was filing in late. And it's like, really, bro? You know, your fucking cats died. You know, this might be it.
Well, he's hoping to hit some sympathy on dead animals, any dead animal. Dead dog, dead bird.
Yeah, Charlie Gordon. This wasn't his filing, but if you read the filing, he didn't file a proper appearance here, and that's not. I'm not trying to be overly anal, but there was a lot going on.
I think in my jurisdiction, the first filing is like an automatic appearance, isn't it? Is it a little different in each jurisdiction like that? Isn't it? I don't think my jurisdiction has a separate appearance.
That's right. Some jurisdictions will take the appearance by the filing in of the first document.
That's what I think.
Yeah,
California is.
In our federal courts that way, but not in state. But
because I remember taking what you were saying, and I was like, wait a second, my guy didn't file an appearance. But then I looked it up, and it said that the first filing is the appearance. Which honestly kind of makes more sense, in my opinion, frankly.
Yeah.
I mean, the idea that an appearance would need to be separated, it just doesn't really...
The thing with the appearance is, who in the fuck do I communicate with, bro? If you haven't filed an appearance, I don't know how to communicate with you via phone or email or however, you know. So that's the reason why it's so important. You know, and this is that filing this little shitbag fucking made in this back in 22. If anybody wants to read this is funny. Pursuant to court may passed upon the motion, blah, 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 you know, pro se, numerous filings that are procedurally confusing. Now he's painting me as being an asshole. The Friday before the 8/11, the undersigned who lives alone except for two pet cats arrived home to find one of the cats dead and the other dying. Despite trying to drive the cat to the fucking emergency vet, he died in the car, bro. I'm tearing up. One cat he found dead, and the other one died in the fucking car on the way to the vet. And the cats had been my beloved pets for 12 years. I've been very distracted with grief from the sudden and unexpected loss of my pets. I had a doctor's appointment on 8/11, was out of town. First off, fuckface, you weren't even in the case. There were 4 other attorneys. This is what I said, by the way. And this was 4 years ago, Joey, you know, much different than today. So, you know, what happened to the other 4 fucking attorneys? Why couldn't they file in? But they come up with fucking, my 2 cats died, bro. Well, first off, you're a fucking cat guy, so that tells me everything.
He goes into a whole story, and then I got into my
Yeah,
1999
yeah.
Volvo, and I
Isn't
was
that
driving at
beautiful?
37 miles an hour, and the speed limit was only 25. I understand that it was an extreme situation, and Fluffy was to the right of me, gasping for air, and I had my right hand on
It
Fluffy
was
while I was
horrible.
crying. I could barely see. It was raining outside, like
Yes, the theatrics and stuff, and it's like, are you kidding, bro? And the court bought it, by the way. It was 7 days fucking late. There are 4 other attorneys in this thing, and then you come out of nowhere with this cat story that the fucking judge bought. It's like this stuff, you can't make it up, bro. I mean, this case right here, if you read this whole thing, you're gonna fucking laugh. But here's the sauce. I just filed a fucking notice of him being suspended. And this is what I would recommend to anybody that's doing anything. Find your roll of attorneys in your state and go in here and look at them periodically. I'm not sure why in the fuck I even did this, but I did, and I found this. Now watch them have changed it. Nope, looky here. Suspended. Whoa, wait a minute. I better open this up and find out what the fuck's going on. So on July 1st, 2024, this
suspended
fucking
because of
shit,
dead
man.
cats.
Suspended. Yeah, maybe that's it. He's went nuts. He
He's a
went
cat
nuts
killer.
over.
That's why he's suspended. Cat
Dude.
killer. He actually killed his
Dude.
cats.
I might have done it, actually. It could have been me. And I feel bad about that.
He's a
But
cat killer.
I filed this stuff in here, and here's the exhibits I want to show you more than anything is to say, I'm crazy about this, so I gave them, here's the roll of attorneys showing where he's fucking suspended. Oh, by the way, here's
Does it
the
say
pre-filing.
why? Does it say why he was
Yeah, it
suspended?
does, and I'll show you here in just a second, and it's funny. It's not funny. It's real though. So
Because
here's me.
that can get pretty brutal if it tells you why.
Dude, it did. And it's in a Supreme Court order, by the way.
Oh Jesus Christ!
Yeah, so you're fucked. So
So
here's
so
me.
he's filing into the case even though he has a Supreme Court suspension.
He's not filing into the case. Just the fact that he's on the docket and hasn't withdrawn from the case is the issue at hand, pursuant to the rules that I very clearly point out to him and everybody else that'll listen. So he's got things that he has to do that the rules clearly outline that he's supposed to, when he's suspended, he's supposed to file an affidavit within 30 days that he's filed a withdrawal into the case. He's notified his client. He's also notified Joey Kimbrough. He's not done any of those things. So this
He was
is me.
suspended while he was on your case.
He's still on my case, bro. They're still sending him stuff right
Oh, I
here.
see. I see.
He literally just got, and this is what I'm raising hell about, order for a hearing on this. Now that I'm raising hell, look who it went to.
I see.
So yeah, he's still fucking getting things. So I'm letting him know, here you go. I'm getting ready to fucking drop one in your ass. Please fix these things, because I think that's important. Oh, by the way, here's this, certified you got down there in Hillbillyville. And
But
then
there's
here's
nothing that he's getting that wouldn't already be on a public docket. You're just being extra
uh-huh.
about the rules, basically.
Well, I have no idea what he's doing. I don't know if in you and me getting things off a public docket is way different than an attorney that's filed in that's serving his client getting things off of a docket and
Okay.
or mailed to him specifically.
I wasn't.
I don't
I thought it
know.
was the same thing. I wasn't aware there was a difference.
No, not at all. Not even close. Here's his gal, his agent that signed for it on this date. So I'm just crazy anal about this stuff when I'm filing things in. And oh, by the way, here's what you asked about earlier. Indiana Supreme Court order. So I went and pulled the fucking order from when he got suspended. Here it is, my gal, Rush again. But it goes through here, and if you read this, this has got some big fucking teeth in it, as to why, and you are suspended from the practice of law in the state of Indiana, and blah, 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 So she gets really fucking, not mean, but you're fucked. Now he's got a chance to, fix things, and that's why, it's went into effect in June, but they're saying, we're going to give you till July 1st of 2024 to fix this stuff, in case there's any delays, blah, blah, blah. All justices concur. Looky who, right here it is. So he fucking didn't file. This is CLE, so that's learning credits. The fees that he's got to pay, you and I don't have to pay those fees, by the way. So he didn't pay his fees to be a bar card, and this one here is some other kind of fucking licensing thing that he has to do. So there are three things that you could be suspended for in the state of Indiana. He cracked all three of them. Attaboy, So it's not
Awesome.
like this one he just didn't get his extended credits. He could probably get that done and fucking get that he didn't pay his fees. He just doesn't give a fuck, and he's still in my shit, in my case. Fuck off. In Loretta, it says you're no longer an attorney, bro, since 2024.
Hmm.
So I'm raising hell about that kind of stuff. I've sent notices to Amex saying I'm getting ready to sue your fucking ass for notice of intent. I mean, there's so many moving parts here that it'd take us a month to have to go through all of this stuff. But I'm doing the same thing with the other co-counsel, because if you read these, and I hope somebody does, because you can really garner a lot from this, is Patrick Kilburn, who's got the title of Director of Commercial Litigation with Lloyd McDaniels as the firm. I love them too. He's the one that's the overseer, and he's got more stringent requirements and stuff through, his professional standards of conduct, and specifically as it points to the ethics rule. I outline that in all this, by the way. You're the boss. You've got a higher level of fucking ethical standards that you're there for. So one thing I'll say here, and then we'll kind of get out of this case because it could go on. Like I said, is I sent this fucking shitbag, the judge, a notice of that I was going to file a judicial grievance, different than a fucking attorney grievance. So it goes through the judicial qualifications through the Supreme Court, different standards, Rule 25. The attorneys is Rule 23, and it goes through the Judicial Disciplinary Commission. So I can show you kind of what that looks like and what Charlie Gordon got too. That's pretty interesting, but I'll show you this one first. This is the fucking judge after I sent to his chambers. Ex parte communication. On 5/8/2026, the court received an ex parte communication from the defendant, that's me, sent via certified mail directly to the undersigned judge's office. The court had contacted the Indiana Supreme Court. Yeah, so did I. The court issues the following order. A copy of the defendant's ex parte shall be filed into the court record by the court. I don't care. It's talking about you, dumbass. A copy of the ex parte shall be sent to the court, to the plaintiff, and to the Indiana Commission. This is all fluff, by the way. He's making it sound like I'm doing something that I'm not. And remember what I said I always do when these dumbasses do that shit. Here's my response. So I came in and said, hey, fuck you. Has nothing to do with the merits of the case. I'm in good faith telling you I'm about ready to drop one in your ass, numbnuts. So that's what this says. And I put that right on the record. I'm talking to him about the canons and what, the importance of what I'm doing, and it should be sealed, and you shouldn't be taking stuff that's in confidence and sharing it with anybody, you fucking shitbag. So that's terribly important to understand what that means. Here's the original that I sent him, and just I very kindly said, here's the things you fucked up. Here's the 17 fucking violations. You're not a fucking judge. You're a clown, and just very nicely said all of that. Then
Why
he took
wouldn't you have put that just on the docket?
because it's supposed to be in confidence, so the Judiciary Committee could have gotten my ass about that, because if you read their rules, from the time they take it to the time they open an investigation against him, which they're doing now, by the way, I've got confirmation of, which is wonderful. I can't be filing that on the docket. And that's what I'm saying. You can't be filing that on the docket either, Judge, even though that's what you're threatening. And they should be telling you that. All of this stuff is in confidence while it's being, decided. So I've put everybody on notice. I've sent all the fucking notices to the attorneys. I've just went fucking crazy. I filed a supplemental complaint. So I actually filed the complaint with the Judiciary Qualifications Committee on him. I sent a supplement in the other day because of that very docket entry you just saw, Brandon, you were asking about, which he's still fucking sending. It's the very relief that I'm asking for. The dumb fucker is still sending stuff to an attorney that's not licensed in the state of Indiana. You talk about unauthorized practice of law, man. So the thing that I have here that I want to show you, and share it, don't share it, I don't care. I would rather everybody not. This came from Adria Maring, and I've sent stuff to her before, but all of my stuff in the past, and you and I laughed about this, Brandon, but it's real, sounded a lot very Sob City. This one didn't. I
Oh,
had
oh
100.
what? Say that again. Whose stuff? Whose stuff was Soft City?
All of my stuff that I've sent in the past, and I'm sure you have too, when it was around complaints against the attorneys. My stuff sounded very Sob City in the past.
I see.
That fucker fucked me, and it's blah 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 blah. And I see all the stupidity people do. I can show you what what I sent them, and it was very professional. It was very structured. It had a tremendous amount of exhibits with it, pointing out all of the discretions, all of that stuff we saw earlier. But here is her. Adria Maring is our executive director of the Indiana Supreme Court, the judicial. She is the fucking disciplinary commission. This is a demand for a written response. So he's required, as you see here, to provide a written response. This was sent to the disciplinary by Joey Kimbrough. If more people started, and I looked at this certification number, he received it on June 15th, so few days ago. He's got 30 days to fucking respond. Here's the discipline rules that I pointed out in my shit to her, so I made her job real easy. He's got 30 days, or I'm getting ready to crack one in your ass, I believe. The judge got this too, by the way, so he's getting it from a different, not the disciplinary commission, but the judicial qualifications. So this is the stuff we have to start doing more of right here, is filing complaints, and not sob-sit complaints. Filing complaints that
Just
actually
very calmly, just point out this is
yes,
here, and this rule says you can't. This is
exactly.
here, and this rule says you can't. This was filed here. This rule says you can't file that there. This
Right.
is here. You don't even need to really say anything. You just say this was filed here. This rule says that can't be filed there. This was
Right.
filed here. This rule says that can't be filed there. It's really just that.
You'll move the needle with the commission, because they get a lot of this stuff from those of us. Like I said, myself, I hold my hand up. They'll get a ton of those things where it's, I've been wronged in the courts and they're all Masons and all that shit. They're
blood,
tired of hearing that. Yeah.
blood bats.
Now it's like, if you come at them and show them the specific violations, I'm showing that this motherfucker is not licensed in our state. You can't get much more clear than that. And here he is still operating, or at least the court's allowing him to operate, and blah, blah, blah. I'm throwing up so much smoke in that case on every fucking thing I can. I'm surprised this judge hasn't jumped off a fucking building, because he's always under the fucking light. When he gets on a hearing with me, it's horrible for him. I know, because I start reciting fucking canons and the fact that you're partial to these guys makes me sick, Your Honor. Blah, 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 blah. I mean, I go at him, and if the shoe were on the other fucking foot, I know you would fucking... So you've had 3 times that they haven't showed up to hearings where I've demanded a fucking dismissal, and you haven't done it, and it's like I've painted this picture, and now I've shared it with the Supreme Court. That's what we have to do. I'm the nicest guy in the fucking world in the court, but... I've said this. I know you'll relate, Brandon. Most people do. If I get beat by us all following the fucking rules, I'm all in, bro. I mean that, because I fucked up. But if I'm getting beat because all of you clowns want to fucking violate the rules that I believe in, very implicitly, by the way, that's a different story. So yesterday, you and I were talking off camera. I had my mediation for this Amex case, and that was kind of I thought that would be it. But, we're in breakout rooms. It's a Zoom call. I talked for 45 minutes to the mediator while they were in a side room on the Zoom call, and then he left me with my 408. I said, "Here's my settlement. Here's what I'll do." Essentially said, "Let's just walk away and be friends." And long story short, he went in their room for 30 minutes, came back, says the little tramp with Amex is not biting, and here's what they'll. And now, mind you, what they offered was only this amount on an amount that's huge, by the way. Most people would think. I turned it down. I said it's zero or nothing. It's zero or fucking nothing because I'll share this part of it. I can. I originally said 150K. You pay me 150. Forget what you think I owe you, and we'll be friends. And I went from that to zero because I wanted to prove to the mediator exactly what I was saying is they're just going to be clowns. They're not here in good faith. And I've got another case pending against them with all of this Charlie Gordon stuff. And, there's all kinds of statutory stuff that I'm going after that I'll file probably at the end of next week. But there's just, they're paying so much money to fight somebody like me. Over 4.5 years, I've got to suspect that they paid way into the 5 figures, if not even 6 figures, because as you saw, I file a lot of fucking shit, and you got to answer that stuff. And they're cracking them for 2 or 3 hours times $6.50 an hour every time I talk, which is often, by the way. Yesterday was 6 hours of fucking mediation at how much they had to, we're splitting that bill, by the way, at $3.40 an hour. And then they've got the attorney's hours on that. There's just so much money that at a business, and it's all over. They think I owe them 15,000 on a credit card. So I mean, it's not even a business decision now. It's like past that. Now it's became ego. And the thing that I shared with you, Brandon, I'll share with everybody else, is when the mediator left, there was a certain level of respect there, I know, because he just kind of grinned and he says, "Dude, you're taking on the 1,000-pound gorilla. Good for you. Good luck." And I said, "Thank you, Mr. Amin." And that was it, So, yeah, I told him, I said, "Bro, I'm secretly happy that they did turn it down because I'm in a group. I know you're in that same group too. I want this to go for another 4.5 years. I think that's the best because you and I doing this, it cost us this much to do it, to defend our stuff. And I'm learning so much, bro. The person that I am is from Amex. They're 4.5 years of nonsense talking about dead cats. So I mean, I've learned so much from that case, and everybody else can too if you tap in and just kind of start from the beginning and start reading, and you'll see the craziness. But it's if I paid an attorney to do that, what I've done over 4.5 years, fuck, I'd be probably in the 6 figures of what I paid, and that's where some people get tapped out. Is I can't do that, and I understand that, But I that was the one that I said I'm going to learn this shit. I'm not going to get a judgment. I'm just going to learn it, and I have, and it's literally the one. I love Amex more than probably my parakeet or whatever the fuck. I don't even have a parakeet, but I do. I truly do love them, even though the level of clownery that they'll play. This is the thing too that the mediator came back that I wasn't understanding, and I'm not sure what he said. They're not going to budge off of the amount, which was very low, unless it gets escalated. And I'm thinking to myself, I don't know what that means is escalated. Now, when I file this other state case against them here in a minute, maybe that checks a box and escalates things and says this guy's nuts and now we got to pay more to defend. I don't know. I don't know what escalation means, but I thought that was something I keyed in on to say we're not going to change until it escalates. I don't know what fuck, dude. I'm already.
You should issue him a promissory note and just see what happens. Fuck it. If you want another 4 years, that's how you get another 4 years.
Well, now we're talking about.
Actually, that might actually close out. That probably ice out your case. Honestly.
Yeah.
That would ice them out. They'd be done. That'd be. I mean, unless they're just getting a free meal ticket. I mean, if they're just getting a free meal ticket and Amex is just like, I don't care if this goes on until the day he dies. You just keep going.
Yeah, they are. And Lloyd McDaniels is getting that very thing. So here's the thing. I've filed twice 41Es against them for failure to prosecute, just like I did in the other one you saw that was successful. And each time, one of them was they hadn't done something for 276 days, and I think the other one was way into the 200s as well. So they're just, I know they're collecting a maintenance fee, it appears to me, that like a monthly retainer kind of thing, just to monitor the case and make sure there's no activity, whatever. The filings, I think they think it's great because when I file in, but you'll see the last few that I've filed, they have not answered at all. Like the Charlie Gordon stuff, they've acquiesced. They haven't said shit. Well, how can you? You know, and the stuff against the other attorneys, even if they had, I looked now, the time is told. You know, our rule 6 is where our timing's at. You've only got 20 days once I file something to answer it. The 20 days has passed, so I would attack that right away procedurally if they did say anything. But it's like they've just kind of thrown in a towel. I honestly thought yesterday was the end. I thought that mediation with me offering that, 0, let's be friends, honestly thought that was it. You know, I expected him to come back and say, all right, you got it, bro. Because I think he wants a win too as a mediator. I think he wants to go to the court. You saw there that he filed in his stuff, his mediation status report, but there wasn't really anything there in it. Tire screen, boom. There wasn't anything. I told you he filed in a fucking paternity suit, you know, like the fucking wrong thing at first. It's like a one-liner, I think, if this is the same one I saw. Yeah, here it is. Dispute was mediated via Zoom on June 18th. The dispute was not resolved. Thanks. That's it, bro. I mean, I could be a mediator. Fucking one-liner. You know, $1,000, 6 hours, you know, whatever. Whatever. You know, he's doing his thing down in Indianapolis. I'm not mad at him. So, there you have it. got a lot going on, bro. A lot going on.
You want to take a quick peek at mine, or are we kind of getting cooked here?
Let's do it. No, I'm good. Let's go.
It doesn't need to be a long thing. Here is my new.
Awesome.
Here is my new. I'm going to do a whole video on this. It's going to be post-course video number 1 for the 3.0 course. So there's going to be a lot of things on here that Joey and I don't see eye to eye.
Right.
And, you know, we'll just have that conversation here, and it'll be good for everybody to hear it because it's the kind of conversations that they're having probably with their families.
I hope so.
Or their loved ones or their girlfriends or whoever, right?
Should be.
So right away, obviously, this is pretty wild. In pro per for both plaintiffs. I'm doing that because the Supreme Court docketed it that way. So fuck it, I'm going to do it here too. And I put that right in the document, right?
Okay.
So we have 2 plaintiffs. We've got the sole proprietorship. I just spelled it differently because how are you going to know who the fuck I'm talking about if I don't spell them differently? I'm not doing this because I'm a sob-sit.
That's right.
I'm doing this because if I don't do it this way, you'll never know who the fuck I'm talking about. So that's why I'm spelling it this way. It has nothing to do with anything else, literally. Even if this wasn't a corporation, I would still do it this way because otherwise how are you going to know who the fuck I'm talking about, right? Jurisdiction, so here's the parties, right? Brandon Joe Williams, all caps registered trademark, is a sole proprietorship, U.S. citizen and resident of Glendale, California. He has privileges and immunities only under statutes, the Civil Rights Act of 1866 and the 14th Amendment, and the cases involved in the incorporation doctrine. He does not have direct access to the Bill of Rights. As a resident of California, he falls under the California Constitution of 1879. Legal fictions were added only into the 14th Amendment class in case, and were never allowed to be considered citizens of the state as made clear in. So I've got a bunch of new cases that I haven't talked too much about. Paul v. Virginia, they literally say right in this case that that corporations are not state citizens, and they cannot be citizens of the states. Literally, it's that simple. Brandon Joe Williams was born a white citizen of Indiana, but is currently a white citizen of California due to a change in domicile. He has absolutely no right to the Civil Rights Act of 1866 or the 14th Amendment, as made clear in Bradwell v. State. Literally, Mr. Miller says citizens of the state have no right to the 14th Amendment at all whatsoever. Literally, it's that simple. Period. He has direct and unabridged access to the Bill of Rights without any need of the incorporation doctrine. This includes the Fifth Amendment, Sixth Amendment, which is only partially incorporated into the 14th Amendment class, and the Third, Seventh, Ninth, and 10th Amendments that are not incorporated. As a white citizen of California, he falls under the California Constitution of 1849. So I was reviewing the 49 and the 79 constitutions. The 79 Constitution in Article 12 has it's an entire article about how corporations are treated as natural persons. And that's when I realized, I was like, if that's the case, then this Constitution was never written for white citizens, because it was good law at that time. It's still good law even to this day. Paul v. Virginia already said corporations aren't state citizens. Mm-hmm. So to me, the only Constitution that applies to my situation is 49, which was never. The AI is like, no, it's never been repealed. It's just kind of presumed that 79 replaced it. Well, that's just a presumption. 79 never replaced it. 79 was a separate constitution for a separate class of citizenship under the 14th Amendment. And then Brendan Joe Williams is not a resident of California and never has been. And then I list a bunch of cases, all the main ones. I didn't go crazy here. I just listed a few of the really huge monster main ones that cover the differences between state and federal citizenship, including the original case that actually created the incorporation doctrine, which is Twining versus New Jersey. And then I put here, the Fifth Amendment right against self-incrimination was later incorporated into the 14th Amendment class in 1964 in Malloy versus Hogan. And the Second Amendment right to bear arms was incorporated in 2010 in McDonnell versus Chicago. But this case is still packed with excellent information on the subject that is expansive, still relevant in today's world, and also easy to read and understand. This is the case that actually created the incorporation doctrine and shows the judicial intent of gifting those various sections of the Bill of Rights to the 14th Amendment class and protecting them federally while they reside in a foreign state of the Union. Mm-hmm. This is where I talk about the writ of certiorari. The plaintiffs recently filed a writ of certiorari together in the same way this amended complaint is set up here, and it was docketed, and it does not violate Rule 9.1 of the Supreme Court rules, which is talking about how you have to have a bar card to represent someone else. City of Glendale is a corporation, 14th Amendment citizen. And then here's where I get into the storyline. We go into lawful money, legal tender. This is the entire section where I give the entire breakdown. I think it's pretty good to give this much information in such a short package. It's just the U.S. citizen or citizen of the United States class was originally created by Congress in the Civil Rights Act of 1866 in order to protect the Negroes that had been released from slavery from the 13th Amendment. It was created in response to the Black Codes in the South and the Dred Scott versus Sanford decision in 1857. Prior to the advent of the Civil Rights Act of 1866, the term citizen of the United States simply meant a white citizen of a state, such as a white Californian. This was clearly defined by Justice Solomon Haydenfeld in Ex parte Knowles. He literally says that verbatim. Mm-hmm. It's not even like you need to decipher it. Congress was worried about how legal their new congressional citizenship class was, and they were also worried about it being repealed when the power shifts in Congress. Their solution was to turn the Civil Rights Act of 1866 into a constitutional amendment, which became the 14th Amendment. This citizenship class is tied to the District of Columbia, not a state of the Union. And this class is only a resident while in a state of the Union, meaning they are not a full citizen of the state. They do not have direct access to the Bill of Rights, but only have access to those privileges and immunities via the incorporation doctrine cases. Currently, U.S. citizens who are resident in California only have partial access to the Fifth and Sixth Amendments, and they have no access to the Third, Seventh, Ninth, or 10th Amendments. All this was covered in the Slaughterhouse cases and Bradwell v. State. And then at this point, you're probably thinking, okay, how is any of this relevant, right? Mm-hmm. Yep. Well, this is where I get into how it's relevant to the case. 31 U.S.C. 5103 is clear that foreign gold and silver coins are not legal tender for debts. This applies to all residents or other national, federal, U.S. citizens under the 14th Amendment because that citizenship class is tied to Congress, not directly into a state. All residents of California are forced to use legal tender as their primary currency. it is only white citizens of California that fall under Article 1, Section 10's decree of using gold and silver coins. The California Commercial Code is the law book regarding the operation of the currency for residents. Every resident in this state, when issuing or handling notes or drafts, is duty bound to this code. In very simple and concise English, it is explained like this. 14th Amendment citizens are tied to the District of Columbia, and their currency operates under 31 U.S.C. 5103 while they are residents in a state. White citizens of California must operate under Article 1, Section 10 of the U.S. Constitution. Mm-hmm. And that's basically how the citizenship ties into the complaint, because the complaint is monetary in nature.
Was that on the other complaint?
No, none of this was on anything. This is all new.
So this is a change that's been made.
All of this is new. All of this is all new.
Okay.
Including the way I split up the two plaintiffs. It's also new as well.
Okay. Was any of that stuff challenged in the first filing? Okay. But my mind goes to, and this is great to have this conversation. It's wonderful because you were there, I wasn't, but I know where they go with things. So he dismissed for something, and
so
he's asking you to amend. Okay.
Number one, res judicata, because a previous bill had been dismissed in small claims court, but it was a totally separate bill and has nothing to do with any of this. The previous complaint was more generalized, like I'd say more Sob City, more like this has been going on for a long time. This has been a major issue for a long time. It's like more vague and more like blob. Like everything is just a big blob. This is way, way, way more cleaned up and precise. Like each bill has its own name. Every single bill with its own name has its own entirely separate causes of action. Like I sliced everything up. And then I talk about res judicata as well here. I'll show it to you. And then the other major reason was just uncertainty. That was it. Wow.
That's interesting.
One of the points of dismissing under a demur is uncertainty, according to the face of the complaint.
Yeah.
And there was really no discussion as to what was uncertain. It's just uncertain. That was it. That was the reasoning.
Weird. Yeah,
so res judicata and uncertainty were the two reasons for the original complaint being, and that's why I'm going so crazy with such intense detail here, because of the uncertainty aspect. It's like, all right, now what's going to be uncertain? Do you know what I mean?
Yeah, the res judicata, I think for that one, Brandon, I would have uploaded my original complaint, and then I would have went to AI and said, hey, we need to get past this. How do we defend against this and answer it and stuff? Because res judicata is just same claims in another court of competent jurisdiction has already been decided kind of thing. And that's where they're hanging their hat on, is how do we get around that? And
well, I didn't use AI, but you'll see the way that I handle it here. So I give the definition of a resident, legal definition. There's a quote here. And then I go into the whole background of how our original negotiable instruments were actually silver certificates, gold certificates, the definition of a dollar, kind of just giving the breakdown of what gold and silver was, what happened to both of them, and then their eventual demise. But you can see how short it is. Mm-hmm. Number 14 is the entire thing. That's it.
Oh, that's good.
I'm not going on and on and on for pages and pages and pages. Definition of money versus currency, and just how the courts typically use lawful money and legal tender, and then also the courts used to use the word specie to specify the differences. Talking about the legal tender cases being the basis of our entire negotiable instrument society, essentially, and then like what is the main basis of the entire series of cases. The main basis was that the District of Columbia is not a state as per Article 1, Section 10. That's it. That's like the whole legal tender cases in one sentence. So, and then I get into the basic functionality and that kind of thing. But as I get through the basic functionality of notes and drafts and kind of how they're negotiated, What's the structure of a Federal Reserve note? What's the definition of it? How is it negotiated? Definition of cash. As we go farther into this, this is where I get into the res judicata part of it, right? So each individual issuance of a note or draft begins an entirely new cycle and would not be subject to any other specific cycles. Each series of steps that are statutory and required, leading all the way from the issuing of a note or draft all the way to discharge or completion, would be one independent and individual cycle. Just because there was a breach involved in an endorsement would not then preclude or prejudice a separate or later breach, even with the same payment or instrument. For example, a failure to dishonor or discharge. Also, just because one instrument or payment had a breach of obligation during a billing cycle would not then preclude or prejudice the cycle of another payment or instrument. Cases covering this point are one Supreme Court case, one Ninth Circuit case, and then one California state case.
Mm-hmm.
Res judicata would only apply to the specific area in the cycle regarding a specific instrument or payment, meaning if a draft was not endorsed properly, then res judicata would only apply to that endorsement for that instrument and would not extend to other breaches of obligation found in that same cycle or in another cycle with another instrument. No different than the idea that if you made a payment with a check, that one check payment would not then give prejudice, effect, or give rise to res judicata as regard to other future payments using other checks, notes, such as Federal Reserve notes, credit cards, or other drafts. The idea that res judicata would apply to later payments of various types makes no sense on an intrinsic level of law because it would then prejudice each and every subsequent payment beyond the first forever. This would utterly destroy commerce nationally. Each individual billing cycle where a draft is issued is not some kind of installment agreement where there is an overarching nexus between the billing periods. Specific services are rendered within specific time frames. A specific amount of electricity is used or consumed during that time period, then there is a draft issued involving only the specific electricity that was used during that specific time period. Then, the implied in fact rate sheet is the contractual amount of negotiable instruments required to be paid upon consumption. That's basically my handling for the res judicata.
Mm-hmm.
And my handling for the uncertainty is just a lot of this background information, the breakdown of the history, the difference in all the citizenship stuff and how state citizens are tied to Article 1, Section 10. Federal citizens are tied to 31 USC 5103. That's kind of like the basis. The third thing that they demurred on was I didn't prove that the defendant had a duty under the CCC, the California Commercial Code. So that's also why I had to go into the citizenship stuff so hard. Because if you don't explain the citizenship stuff, it's hard to understand why the defendant would have a duty. If you don't understand what a resident is and how a resident is tied to the District of Columbia, and you don't understand how a citizen of the District of Columbia is tied to legal tender, and they're actually not even allowed to possess gold at all, you wouldn't really understand the duty aspect of the California Commercial Code. And none of this was explained in the original complaint, by the way. None of it.
Okay.
So, and then also when I start getting into the causes of action, you can see here, they're the 1305, the one that I found fairly recently that I've talked to you about.
Mm-hmm.
And then it just goes into, it breaks down the exact duty, the exact breakdown of how it's there. You know, everything is really broken down. So it specifically, this whole amended complaint was specifically designed around all of the reasons why the original complaint was demurred. But that's it.
Do you think that they're going? He's a strong complaint or not? I think you already suspect, and I know this for a fact. They're going to come at you procedurally, just like they did with the demur. You know, I don't want to answer your shit, so I'm just going to try to snuff you out, kind of thing.
I'm at the point now, dude. I'm just like I said when we were talking. If they tell me I didn't do this, this, and this, then I'll do this, this, and this. If they say you didn't do this, this, and this, and it's another demur, and you need to write another complaint, fine. I'll write another one. And at that time, I'll review the whole complaint and see if I need to change anything more or if there's any new discoveries or anything else needs to get added. And if not, then it'll be very easy just to make a couple adjustments, file it back in. And then if they demur it a third time and they say, these are the reasons why, no, fine, no problem, take it back, make adjustments, fourth filing, fourth amended complaint, fifth, sixth, seventh, eighth, ninth.
Yeah.
Eventually, they're going to run out of that runway.
Yeah, that's the way it's supposed to be too. That's me actually. When I'm snapping at the attorneys, their ego doesn't allow them to make the changes that I'm asking for. The easiest way to fucking defend against me with all of that shit, one, take Matt Elkins off the fucking docket, you dumbass.
That's just
File a
that's just
fucking
retarded.
Just
That's just
it is,
retarded.
and you and I are smart enough to know that we would do exactly that. So that
It's not
mediator,
even worth like it's more worth to even talk about it than it is to just take his name off. Who gives a fuck? That's just ridiculous.
it's childish, but it's a rule that I can't get past because I'm very big on rules, man. And it's like, because I know that's the whole component to the procedural. The mediator sent something to me yesterday. I told you that he filed on our docket a fucking paternity fucking suit. And I sent him, dude, I could show you the email, bro. And this proves my point and yours. Is I sent him an email and I said, Mr. Amin, it appears you docketed the wrong case on our, our docket. And he immediately sent me back, see, there's proof that shit happens. He didn't have shit. He had the asterisks in there, and I knew what he was saying. That's completely different than what he and I had a conversation about when I'm telling him all of this fucking stupidity of procedural, nonsensical stuff that they won't fix. The difference is, bro, I told you, and minutes later you docketed the right fucking thing. That's the way it's supposed to happen. Hey, Brandon, I think you're a fucking asshole, and here's what you ought to change. Okay, bro, thank you so much for telling me, and here I changed it.
It's taken me a long time to get here. The first year, every single tiny little thing, and you were there for it, drove me into practically wanting to set buildings on fire. Not literally,
Yeah,
like
right.
I'm not literally, but like if I had that part in my head, I would have been ready. Like it was like that intense. And then after getting my ass handed to me nonstop all year in 2025, I just kind of backed off and started reading cases all year because I just didn't care about case law, didn't care about procedure, nothing. Fuck everybody. I'm just going to run in these courts and just set everything on fire. That's what I originally genuinely thought was going to work. I genuinely believed that. You were there for all of that. You pretty much just kind of sat aside and kind of chuckled a little bit, and you kind of just let me burst into flames and burn gas stations to the ground, left, right, and center. And you just tried to have little talks with me, gently here and there, and I would tell you to go fuck yourself, and I would say we need to burn everything to the ground. And then by the end of 2024, I finally realized, okay, maybe Joey's right. So I started to read cases all through 2025. I spent almost the entire year just reading cases. That's when I wrote the treatise on the word person. That's when I wrote my book. That's also when I wrote the writ of certiorari. Those were like the three products of all the case law reading. And that's when everything shifted from the non-citizen national stuff over to the state citizen stuff, because all the cases talk about it. And it's like case law, case law, case law, case law, case law, case law. I mean, when I had one piece of case law, I was like ready to run with it. But then I decided I want to dig up every single piece. Every single, and I don't know if you've been seeing my flow charts and stuff like that. I don't know if you ever opened them.
Yeah, I got one from you. You asked me to look at it. I thought I saw before I think you published it and stuff. And the flow was good, man. I didn't see anything wrong with it.
Oh no, that was the litigation one, because I actually
okay.
wanted you to actually look at that one. You've
Yeah.
probably never seen this other one. It's not really a flow chart. I call it a flow chart, but it's not really a flow chart. It's more like just a chart. But this is the one that I created. And I'm not going to go into this in any detail at all. I'm just going to 2 seconds. I'm just going to give you an eagle view down, and then we're going to move on. So this is some important notes and some important definitions. And then on the left-hand side, it's the white citizen of the state. On the right-hand side, it's 14th Amendment protections and obligations. And then over here on the right-hand side, I have a full timeline of every single thing that happened. So 1, Dred Scott versus Sanford. 2, Civil War begins. 3, congressional debates over slavery. 4, 13th Amendment. 5, black codes. So it's a step by step. Every single major event, all the way up to basically 1982 with the Plyler v. Doe case, and then we have some random stuff kind of pointing toward the sole prop, kind of so you can understand what the sole prop is. And then down here, this blue, this is all just quotes from court cases, and I just have tons of them. It's all of these quotes are all talking about state versus federal citizenship, the Negroes coming out of slavery, whatever it is. So I basically found all of this case law, and it's like I only wanted quotes that were like really clear. They weren't full of other stuff. They were really, really heavy hitting. Like these are like Brandon's hand picked, like all of 2025. It took me to collect these. Essentially, this is like the cream of the cream of the cream of the crop, basically, right? And just having one of these is powerful, but having all of them on a single chart is like fucking completely insane. That's why I tell people, I'm like, you can literally just buy my poster and go into court, and you've got everything on one sheet, essentially, right? I didn't have any of this before. So that sheet and having all that called then is now transforming into me being able to explain, like you saw in my thing. If I share the screen again, I'm now able to essentially explain the whole thing in, like, it's not a very detailed explanation. It's not a full timeline, but like this right here is basically like point number 10. This is pretty much like the whole story, really. And it's amazing, in my opinion, that I'm able to put all of this into,
one paragraph.
It's a large paragraph, but this is like 10,000 hours of research in one paragraph, essentially.
Yeah, that's impressive.
So, and then at the bottom of this, I thought you'd like this, I have a flow chart, and this is a flow chart of the drawer issues the draft, drawee receives the draft, what happens with all these notes, and there's just certain presumptions, like in the California Evidence Code, there's 2 specific presumptions that activate. I show you exactly where they activate. Definition of the word payment, negotiation of the instrument, and then dishonor or accepting the instrument. So this was custom made specifically for this case. And then also I have a special closing message because they said the first one was uncertain. Okay, well, I didn't know really what else to do. I have all this detail now, but just at the very end, it's like, all right, I got a flow chart. I've got all the storyline. I've got background information, all the stuff that wasn't on the first one. But just in case that's not enough, I have this special closing message, and it says here, the plaintiffs have extensive information called on both the differences between state and federal citizenship and on the California Commercial Code. This includes an entire treatise, an entire best-selling book on Amazon, an entire online free course, and multiple large flowcharts that are not a part of this verified complaint. The flowchart on the differences between state and federal citizenship also contains a full timeline of each and every event that built up to the separation between the state and federal citizenship classes, complete with specific case law to fill out and prove each individual step of the timeline. This flowchart can also be expanded if needed to show a timeline of each and every step of the incorporation doctrine if that much detail is required or desired by this court. Any additional information needed by this court or the defendant can be rapidly and easily supplied as the information is already culled. Practically every major salient quote from case law regarding the difference between state and federal citizenship has been culled and placed into a flowchart. Then the flowchart on the UCC is more of an overview of the entire operation of notes and drafts, which is also available, and I can convert it over to the CCC versions of each individual flowchart item for integration into this case. In an effort to keep this verified complaint more brief, that information has not been added, but this information or any other confusions can and will be rapidly handled in an organized fashion. Please inform the plaintiffs of the confusion either live at a hearing or privately, and the plaintiffs will immediately and effectively provide precise case law, timelines, etc. What is needed by the plaintiffs is specifics as to exactly what areas of this verified complaint are unclear or uncertain. If exact and specific numbers or sections are pinpointed, additional information is available to fill in any gaps that may have been left behind. The plaintiffs are both very excited to handle and address each and every individual concern or confusion with great enthusiasm. Thank you for your time and attention to reading and addressing this verified complaint.
There you go.
So it's like I'm trying to make it to where it's like uncertain, like,
yeah,
you know what I mean?
Well, that very thing may be the grounds for your appellate review if it goes that way, and we both know it probably will. Is, I need uncertainty defined because it just leaves me without relief, and I need relief. I think we all get relief somehow. If it's, if it comes down to your complaint gets turned over, you've got the appellate courts. If that gets turned over, you have the ability to take your pound of flesh, like I am with some of these complaints against the bar cards, whatever. Just saying uncertainty and fucking fuck you. That works for most people. You're not one of them that, you're questioning and, hey man, tell me what uncertainty is and where it lies, and I'll fix that for you. That part I agree with is, they're going to have a tough time just using very broad brush, dismissals from you when you're saying, hey, I'm willing to give you whatever you want. Just tell me what it is you want to answer, what it is you say you need answered or whatever. That at some point, and here's the reality that you and I know, and I've faced this too, is taking on corporations that are municipalities specifically is a really tough hill to fucking climb because they know they have an endless fucking purse. So Carl, I'm surprised Carl's even fucking dealing with you, to be honest. When I deal with state agencies, they usually hire outside firms. Fuck it, I'll just write a check. You're the one paying the fucking taxes anyway, is how they look at it, and we'll just keep this going till the end of time. So for Carl to actually tap in, him and his lemon drop ass, I'm actually kind of impressed because that usually doesn't happen with municipalities, And it might. If fucking Brandon's
he handled everything in my federal case back in 2024.
Yeah.
I filed a really shitty federal case that was dismissed for lack of jurisdiction almost immediately, which was correct. I just learned my lesson on that one.
Mm-hmm.
But that was Carl. I did a meet and confer with him when he filed in that motion to dismiss. So it's been Carl for this whole time, everything.
Yeah, that's good. Well, at some point, he either fucking strokes out, misses Pride Month, whatever it is that he does, and hires somebody outside, or I think at some point, this is just me looking into the crystal ball, he's going to start saying like vexatious litigant.
He's already threatened that. I told him to do it. I told him to do it.
Yeah, do it, bro. Let's fucking quit talking about it.
But recently he started filing in for sanctions. But there's a part of me, especially after this most recent filing, there's a part of me that thinks, and this is not ego, I'm actually being like very non-egotistical when I say this. I have a feeling, first off, even if I didn't know about all the negotiable instrument stuff, I am trying so hard to learn everything. I dress up really fucking nice when I go in there. He's very impressed. Mm-hmm. I go in person. No one does. I'm in a full fucking custom suit, head to toe, perfectly pressed button-up shirt. I have the handkerchief that has the different colors kind of flared out like this. I've got my civil peace flag pin that I wear. I wear a pin. I have a wooden watch. I got my rings. I've got dress shoes. I've got a whole entourage
Yeah.
that with me. I'm as quiet. You couldn't hear a mouse squeak the whole time. Carefully, quietly listening. I go up. I get straight to business. I'm opening up my stuff. Bam! I'm in it. I move the mic straight to my mouth. I'm on it. He told me in our last hearing, the judge. He said, Mr. Williams, you're more organized than almost anyone I see in my courtroom, even the attorneys. Because I literally have his tentative order. So my judge, Mr. Tavelman, he issues tentatives the day before. He issues them by 3 p.m., and then you have until 4 p.m. to issue an email requesting oral argument. If the tentative does not require oral argument and no party demands oral argument, then it's just the tentative becomes the final.
Yeah.
But if anybody requests oral via email, it's very easy. You already have the tentative. So I have the tentative, and then I have the areas marked that I want to cover. I open my brief, and I say, Your Honor, thank you very much for your tentative. I have 3 areas of the tentative that I'd like to cover. It's the 3 areas that are right before your final bold statements in each section. And I want to go over all 3 of them. Item number 1, and I was talking about that. Item number 2, and I was talking about that. Item number 3. And that's when he said, I hardly ever get anybody who's as organized as you are.
It's good. Yeah.
Even the attorneys, even the bar card attorneys, right? So, and then I had a flow chart, but it was my entire UCC flow chart, the whole thing. I pulled that out, and he's like, "No, we're not gonna dive into the whole UCC flow chart." And I said, "Fine." That's when I went home, and I just said, "You know what? Fuck it. I'm just gonna rewrite this thing. It ain't gonna hurt nobody." It took me like 15 hours to write all what you just saw.
Mm-hmm.
Because it's 19 causes of action. It goes through. I read the entire 1849 Constitution, and I read the entire 1879 Constitution, and I made causes of action out of literally every single point that I felt I could comfortably make a cause of action out of. And then there's a few other ones that are not constitutional, and then you have the CCC, the 3 CCC 1305s, and that added up to 19 causes of action. So I'm just trying to find any possible way to somehow survive the demur. That's really all I'm trying to do.
Yeah, there's no doubt about that. That's going to be the hill right there is the demur. But it's
But you saw the way I explained it.
Yeah.
You've never seen me break everything down like that
Good.
before.
Yeah, that's good. The unfortunate thing for you and I thinking about this stuff with municipalities is you're seeing me handle a very similar thing with property taxes, but completely different. They're going to shut your power off. They're going to steal my fucking house. We're going at it from 2 different angles here, which is good, and we should, and people need to see both angles. I think that's terribly important. I'm going more of the administrative process that's going to lead to court. Now, I'll leave all of that stuff out because to me, it doesn't make sense, and it's not going to help me any as far as my citizenship status and all of that. I just don't believe that will for what I'm fighting with a municipality the same. The thing that's unfortunate is too bad that they do have the power to be able to shut your shit off. It's like if they didn't do that and they could come fuck with you in some other way, that would be good. But
when they shut it off, I wake up in the morning and the power's off. They've done it twice now, and I just walk over there. It's a walkable distance from where I'm at,
Mm-hmm.
and I pay half of whatever it is that I supposedly owe. So I think the last time I paid it was, I don't know, I don't have the receipt here. My power is back on damn near by the time I get home.
That's good.
So it's really not, I don't know, because everyone asks me, what is the power and how's it off and how long is it off? I don't know. I'm in a much newer apartment complex. It could just be a click of a mouse on a computer.
Probably, yeah.
And, you for those of you who have homes,
Yeah.
if you have a smart meter, that might be why the whole smart meter thing. People say the smart meters, they don't want them because they output radiation or whatever the fuck it is.
Yeah.
But think about this. Maybe the smart meters are being put in because they don't have to send someone to your house to turn off your power. They just click the mouse on the computer and the power turns off.
Mm-hmm.
Because if I had a home and it didn't have a smart meter, I'm assuming they would have to come out and manually turn off my power. There's pros and cons to both of those. I mean, I kind of like having it so easy because when they turn it off, I just go in and I pay, and within like an hour, it's back on. I just don't open my fridge. That's the only thing. I can't open my fridge. But the fridge stays cold. I didn't have anything go bad because it was only off for like 2 or 3 hours. Well, the first time it was off for like 6 or 7 hours. The second time it was only off for like 2 hours. And then I didn't even get a bill this month. I don't want to talk too soon because you never know. Maybe I'll get one next month and it'll just have this last month's on it. But I just, for whatever reason, didn't get one this month. But I just filed another small claims case with them for some later bills that are different than the 3 bills that are being covered in this lawsuit. So they're about ready to get served for another one. I haven't even announced that one yet. Plus, I wanted to test out filing a small claims case online. Holy Jesus, was that easy.
Yeah,
holy Jesus. It's an $848 lawsuit.
Oh, wow.
It cost me $30 to file it with a $20 online e-filing fee. So if I would have gone down the street to the courthouse and filed it, it would have been $30 to file. It took me all about 5 minutes to put together. That was pretty mind-blowing. I was just shocked. And it was approved within 24 hours.
Mm-hmm. Time to serve them.
So I just kind of wanted to they turned off my power a second time for some other bills that are not involved in the lawsuit we're currently in state court. So I just kind of wanted to go. I did small claims before, but that was dismissed because of lack of damages. I wanted to do small claims again. I wanted to file it online. I wanted to see how fast and how easy I could get it done.
Mm-hmm.
I wanted to not attach anything. I just wanted to make it super simple. And then I wanted to use CCC 1305, which I don't need damages to structure a cause of action. So I'm going to small claims for an action that needs no damages. I'm not even going to talk about damages. I don't need them to structure a cause of action. Good. And then also, the California Evidence Code 633 and 634 are both presumptions that I'll show it to you. I have it on my flowchart. On the flowchart that was attached to I found these while I was doing 3.0. When you watch 3.0, we're going through the rules of civil procedure or the rules of evidence. And I'm reading through the rules of evidence and I get to these 2 points, 633 and 634. And I live on the camera, I just about pass out. So California Evidence Code section 633 says, I still can't believe it. I literally still can't believe it. Reading it is I just still can't even. An obligation delivered up to the debtor is presumed to have been paid.
Yeah. Presumed to have been paid.
And look at this one. 634. A person in possession of an order on himself for the payment of money or delivery of a thing is presumed to have paid the money or delivered the thing accordingly.
Isn't that something?
So I wrote a small claims case and I said CCC 1305. They failed to dishonor or mark the payment. I said I don't need damages, and they're the ones that have to prove that I didn't pay because CEC 633 and 634 places all the evidence requirements on them. It's already, I'm here basically just kind of showed up just to say, yeah, I paid. That's.
Well, the presumption is that you paid. Now, we both know the arrogance that they have. They're not going to rebut that presumption, which would throw the burden of proof back on you. that would be that simple is to say, "Oh no, you haven't paid, fucker, and here's how we take payments." You've got to rebut it, but we know they won't. It's
That's the
like
point.
they'll let the presumption stand, and now it becomes fact and law. You know that, I know that, most people don't. Is like, they get all caught up in the presumption, and you and I can get excited about that because we know what it says and what they should be. Carl and his lemon drops should be,
Well,
rebutting that shit right away.
small claims is the last time I was in small claims, it was the customer service lady. Attorneys are not allowed in small claims.
Oh wow.
So when I go in there for this next small claims, it's going to be the customer service lady, Holly Ederol. It's not going to be
She's
Carl.
not going to say anything.
No, the last time they don't know anything. All she
Right.
said last time was, "Your Honor, we accept cash, check, money orders, credit card."
Well,
She,
that there
she didn't
could
say
be,
anything else.
that could be her trying to rebut your presumption that it's paid. But
Yeah, but she
didn't say
had
it.
no idea.
Right.
She had no clue about it. That's
Right.
all she's like, "Your Honor, I don't know what the fuck he's talking about." Basically, she didn't say
Yeah.
that, but that's basically what her body language was. She just said, "Your Honor, we accept cash, credit card." And my rebuttal to that was, "Your Honor, what I sent them is cash." So
There you go.
that's true.
going
What
back
I
and
sent them
forth.
is cash, right?
Yeah.
But it was previously dismissed because of a lack of damages,
Hmm.
and that's why I'm so excited about the CCC 1305, because you don't need damages to structure a cause of action. So the fact that they didn't honor or discharge, they didn't apply or dishonor the payments, and they turned off my power. The second time they turned the power off, which is fairly recently, the power was only off for like fucking 3 hours. So the downside of the 1305 charges is I can't all consequential or special damages, you can't have any of that with CCC 1305.
Okay.
So penal code damages, none of that. It's all out. The way that it's worded, 1305, is it's there just to make whole the aggrieved party.
Yeah.
I sent in $848.09 worth of instruments. They were lost, stolen. I don't know what happened to them. As a result, some stuff happened, but that's all irrelevant. I just want the value of the $848.09. That's all I want.
There you go.
That's CCC 1305. So I put all that on the SC 100 small claims, and I tried to do it in a way where I didn't need to attach any paper. It's literally just all explained in the little paragraph that they give you, because they give you 2 paragraphs. So I'm trying to just condense everything down, and then I'm going to send the flow chart that I made for the state case into that one. So they'll get the flow chart, and then it's just going to have the instruments that were sent, and that's all I'm going to send.
Wouldn't it be funny if they sent you back the very same instrument that you sent them and said, "Here you go, it's back. It's been returned," or because normally that's what people ask for. Pursuant to the dishonor it or return me my shit kind of thing. I've seen some of those complaints written up. But returning you the same instrument that you used to pay, wouldn't that be funny?
Well, if they return, that wouldn't really change anything.
No.
No, that'd be UCC 3-603B. That wouldn't really, it would still discharge. It wouldn't make any difference.
Okay. Yeah. See how it goes, man. That'll be exciting, I guess, to see how they take it.
Well, yeah, last time it was fuck you, no damages. So this time I'm coming in with,
We're
I
not
don't need them
talking about
now.
damages, that's
Yeah.
right. Yeah. That's cool. We'll see how they take it. It's part of the learning process and kind of what you're going through and seeing everything and testing. And that's the thing that, right, wrong, or indifferent, it doesn't matter. It's the thing that most people, as you well know, or almost all people, are just not willing to do, is to test. God forbid, I've had to test 1,000 things too. And honestly, my testing is more around the procedural side of things to see not what I can get away with. That's not the right way to put it. but how that I can keep them moving forward pursuant to the rules, that are written. And because I know what the statutes say, what the statutes say, all of that stuff. It's like you've gotten snuffed out, I've gotten snuffed out. It's like now you kind of see the procedural component, and that's what you're looking for now, is to say, okay, cool, I've got some claims, I've tested all of those to see where I'm going to get pushback. Now how can I keep everything alive that I know works, and that's the procedural component. So that'll be interesting to see, man, getting past the demurs or getting the small claims action or whatever that is, and once you get you got it, it's like, that's me with my 1681. I won't lose a 1681 case. I'm not saying that arrogantly. It's because I know what it says, and I know what I can get away with, and I know what, the other party is the key, man. And I know this is like getting inside Experience head and knowing that they don't want to fucking take on crazy claims. And, I can show you my settlements and stuff there and show you it's very real. But whether you have the ability to get in Carl's kind of head, or if he sees where you've got some valid stuff that you're going to be able to move the needle, and or he's not going to be able to affect you. That's kind of what I was painting the picture of earlier. They can shut your power off. It becomes a much bigger deal for them to come take my fucking property if I don't pay the $2K in property taxes next year. That goes for a year, then there's the fucking tax sale they got to do and all that shit. Well, by then I've worn them out in court.
I don't have any powers off. I wake up, I get dressed, get a shower, walk over there, pay whatever it is. It's only a percentage of what they say I owe. I don't owe them anything, but it's a percentage of what they think I owe. Mm-hmm. A percentage of what they think I haven't paid, of which I have. And then within an hour or two, literally, the first time I went for a motorcycle ride in the mountains, because they said they'd have it back on by 5. So I just went for a motorcycle ride in the mountains, came home, and powered back on again. So to me, it's not, and I don't know what it is. There's some kind of pattern to it. They only do it every 4 months. Because I go in and I pay, and then it's like 4 months on the day, they'll turn it off again the second time.
Okay.
So I think from that date, which I have the receipt over here, so I think 4 months from that date will be the next time they'll turn it off.
Okay.
And as far as I'm concerned, I'm ready to just ride that out till the end of fucking time.
Yeah. Until you find the winning formula, small claims or whatever that is, that, it's right now, and as it's not a pain in the ass for you, but most people would be viewing that whole process and say, oh, fuck this is just too much of a pain in the ass, and just not wanting to deal with getting it shut off, then going and paying and all of that stuff. They'll make excuses and everything. Meanwhile, you're testing everything out. Kudos to you for that. And, if and when you find that formula, that's the fun thing,
Well, I think the secret is having a platform. If I was doing this by myself and I didn't have a platform, it wouldn't be very fun. I think having a platform makes it fun for so many reasons. You have fans. You can make money on advertising that gets run on your YouTube channel. Other people are struggling. Inflation's getting out of hand. There's a lot of people. For example, just like you and I have talked, they've raised property tax rates across the whole country, some asinine amount. So people hit me up. Does this apply to that? Can I do that with that? Yes. Okay. It's becoming a really cool group empowerment activity, and it's become my whole life, my profession, my love, my passion. It's like an art project plus my job, plus my career, plus my. Mm-hmm. So for me, it's different, I think, than a lot of people. But I think there are a lot of people out there. We get a lot of veterans and stuff, who want that battle, they want that warfare, they want that life.
Yep. I have 3 Marines right now in my program.
That's what I mean. So I don't know. I obviously what we do is not for everyone, but I think we offer something that no one's ever offered, that I think there are plenty of people out there, especially as more and more people are becoming defendants, especially as more and more people are having inflationary issues and other issues. I think having because for me, I don't care at all about having my power turned off. I mean, it literally does nothing. I mean, in fact, I think I get a little excited when I wake
get
up and
some
my
candles
power's
out
off.
and fuck
I'm
it.
serious. I wake up and I'm like, oh, there it is.
Yeah.
I'm gonna have a new receipt. Okay, which drafts did I already send in? I sent in these 2. Which ones were the ones from the last case? Oh, that was these 3. So I can't use those anymore. That would be res judicata. But these 2 new ones that I've used over the last 4 months, those are going to be the. So for me, it's just another lawsuit. It's 2 billing periods, power turned off, power turned on. That's a lawsuit period. So in 4 months, I'm going to have another one. And then in 4 months, I'm going to have another one. And then in 4 months, I'm going to have another one. That's how I look at it. I look at it as just content, basically.
Well, that's true. It is. I think I got this figured out. I saw somebody post today. Brandon, that you would get more followers if you just get in the court of equity, bro. I mean.
Oh, now we're talking.
Equity, bro. You just
Now
don't
we're
understand, bro.
talking.
People would come back to your
Now
platform
we're
if you get
talking.
equity.
Oh, man, that's what it
That
is.
recipe fucking
And I'm
up.
not a Freemason. That's the other big issue.
That's the fuck.
See what I mean? See?
NDAs.
If
equity,
I was a Freemason and I did equity,
you'd have it, bro.
I'd probably just rapture out though. I'd probably be gone. I'd probably just hover into the air and fucking.
You just think things and it'd happen, man.
Dude.
You wouldn't even have to file shit and all that.
I'd have judges filing. One of our clients. Remember one of our. I don't remember which name. Don't say their name. One of our clients had somebody else file a lawsuit with them as the plaintiff. Remember that?
Yeah.
I forgot about that.
Yeah.
So the judge is going to file a complaint on my behalf with me as the plaintiff, and then the first thing he's going to do is write the order and file it in. He's good. He won the case.
Matter of fact, it's against the law for you to go pay your electric bill. Don't do it ever again. I don't want you fucking around with it.
He writes a permanent injunction.
Yeah.
Brandon
Your
Joe
injunction
Williams.
to not pay
Brandon
your-
Joe Williams is hereby forever granted.
Dude, I
Free
try
electricity.
not to be. I saw that comment today, and I'm like, oh my god, for the love of God, it's never gonna end. It's like I try to be super respectful, and I ask this, and there's some other comments that people, I think that some people want to make themselves smarter. But some of them is like, I truly want to know this, and I know you do too. If there is an equity court with NDAs and Masons are running it, please tell me the fucking cause number, one, and I'll go research it for you. You don't have to fuck with it. But when you say things like, dude, give me a cause number, people run. They run away because they saw a video and somebody said that there's courts of equity and all this shit. And it's like,
Well, there are in a couple states, like in,
Well, there
in like
are.
Massachusetts
Delaware
and
and- yeah,
Delaware,
yeah.
right? Yeah,
Yeah.
I'm aware of the
Chancery
fact.
courts. Yeah.
But the thing is that an equity court is, it's just a fucking, it's just bench trials. That's all it is, just bench trials. It's bench trials. You know who uses equity courts? Huge corporations.
Yeah.
And they use it because if they want something done, it's kind of like you with your 1681 claims.
Mm-hmm.
There's a whole bunch of shit that they can just take into the equity court and they'll just win every single time. There's a whole bunch of different things.
10 million 1681 cases come across. Fuck it. Go ahead and create a 1681 court of law, kind of thing to get.
That's what it is. That's what the equity courts are, right?
Yeah.
And see what happens is, and I've said this a million times, someone will file in something that they think is magic equity magic, which, let's say, for example, subrogation. And what'll happen is the prosecutor, they'll file in some writ of subrogation or whatever, and the prosecutor will dump the case, and they
Doesn't
say
have time to fuck with it, or
and they say,
whatever.
look, see what happens when you file in equity?
Exactly.
You win. But what actually happened was the prosecutor is drunk and is drinking heavily all the time, maybe on drugs because they hate themselves, they hate their life. They have 10,000 other cases. They're
He's short two attorneys already.
He's short two attorneys. One's out sick, and you could have filed a literal entire paragraphs in the Latin language completely.
Yeah.
All Latin. It could have looked like a tome from
Uh-huh.
4,000 years ago, and he would have dismissed the case.
And now somebody's running that up the flagpole saying, I figured it out, I've got it, and then
Equity.
Johnny's gonna try it over here in Wisconsin, and Johnny's gonna get fucking smoked because he goes up against a prosecutor that's got a full staff, and it's like your experience in your court and my experience in my court and the other 92 district courts. There's a real high likelihood. I see this because I'm in a lot of district courts right now because I have a lot of cohort members across the entire United States. Even though you would think that everything moves in 1681 the exact fucking same, with the same federal rules and all that other shit, they don't, bro. You got human nature in there with the judge that in Texas doesn't necessarily like fucking soft sits or whatever. And I've told you this, California's fucking the place to be for 1681. Dude, my client and my people
Dude, California's the place to be for everything.
Dude,
It's
fucking
the place to be for everything, dude.
they
Like,
threw money at Saiko, bro. And they've thrown money in San Diego at Rudy. They've thrown money. Everybody that's in California is just getting fucking money thrown at them. It's like,
because California, first off, there's more money here. If California broke off and was its own country, it's like the fourth or fifth largest economy on the planet. If it was its own country, right? Yeah. It's like 24 or 23% of the entire GDP of the entire United States. Or I'm sorry, the Ninth Circuit's that much. So it's probably like 15% or 12% of the entire GDP. I don't know. So it's just a lot. It's just huge. Mm-hmm. And then also, it's the most litigious state, if not probably the second to maybe New York.
New York, yeah.
And the next thing is there's so many liberals and liberal judges and stuff. They're more willing to talk about things that if you brought it up in Texas, they'd literally just tell you to fucking get out. They wouldn't even file anything on the docket.
Yeah, go fuck yourself. Yeah, that's right. It's just, my point is everybody's experience is going to be completely different depending where you're at geographically. And I've seen it. I get to see it, where Sonny in Florida had a different go than, and even me in Indiana and stuff than somebody in, our friends out west. It's funny to see that in action and think, fuck, this should be the same thing. People think it's a cookie cutter and it's not. It's completely different product all over, even though it's the same thing you're building. So yeah, litigation is interesting, bro, and you know that. And it's I'm still excited about whether I'm a plaintiff, I get even more excited when I'm a defendant. I truly, and that's not happenstance. It's not horseshit. It's when if which I don't get very much anymore, but when it happens, it's like, it's a different kind of a feeling to go after that procedural component because I know it's there. It's in every case across the states, by the way. I could look at anybody's case where they're being sued. 100% say this without any kind of arrogance. It's gone, bro. I don't care if it's a foreclosure. I don't care if it's whatever. Now, there'll be people, the emotional component is what gets flared up. The anxiety, the going up against the courts. Yes, they're going to lie to you. Yes, they're going to say nasty things about you and your mom or whatever the fuck they try to do to try to get you emotionally charged. You just got to get in there and just do what I showed you earlier, which is the whole procedural component. I don't care if that's what that was a fucking a car note, but it could be a foreclosure. It could be anything, credit card, suit, whatever it is. It's the same mechanics that you go through procedurally, and some people just, they get emotionally fucked up and, they're coming after my house. I get that. I truly do, man. I would probably be in the same boat, but take 2 deep breaths, look at what's going on, look at the little things that, that are much bigger than what you might think, the appearances that aren't there, the affidavits that weren't filed. Just do a little bit of research, man. We have tools now, as you know, that, dude, one of my cohort members said this to me, and it makes so much sense. Dude, we're getting to a point, we're already there, that he said my 14-year-old daughter can fucking beat somebody that paid $300,000 for law school by just having, and I believe that implicitly. It's like it
For
really is
real.
true.
I think the legal profession will be the first profession that AI is going to take down.
I agree. Now there's a component to that. In my folks when we're in the cohort see that pretty fast is you can put anything out there and you can argue anything, but there's still the human component that you have to go to the hearing. You have to know what you're saying in
Yeah.
some regard to what it is.
Well, if you're doing my shit, AI won't even help you. So there's also that too.
That's right. That's true too.
AI goes fucking absolutely ballistic ape shit if you plug any of my shit into it.
Yeah. So
It goes fucking crazy. No court has ever fucking solved it, and you're crazy. You're gonna get sanctioned and fucking, molested by the court.
yeah, it's there's still that human component that um, I know I'm valuable in that regard. That's not. I just know that there's a worth that I have. We can build it out.
The
And what's
reason why,
you
the reason,
know,
I'm just going to cut you off right there because
yeah.
I want to say something on what you're talking about. The reason why the legal profession is going to be the first thing to die with AI is because the legal profession has lost its heart and soul and mind.
Agree.
And AI can do the dumbass paper shuffling
Yep.
that the legal profession has become. If you read cases from the 1800s, and you read Roger B. Taney, and you read Samuel Freeman Miller, and you read those, AI would not be able to replace what the law used to be in this country. If we still had real courts, and we were talking about real shit, and it wasn't just a bunch of cocksuckery, AI would not have this kind of impact that it is having on the legal world.
Yeah, I would agree. Yeah. Yeah, there's a component there that you've been in there long enough, and I know I have too, is to see what you've seen it in my filings and stuff I was talking about earlier. There's an ego component too, that if somebody sees you or I coming, oh fuck them, they're pro se, they don't know anything. That don't underestimate a motherfucker that's got a beard. It's like he's like, bro, don't do that. Yeah, I got all the time in the world, and you got to fucking so. Dude, I get people calling me and they're fucking crying. If you talk to me about joining the cohort, I'll spend more time talking you out of it. That's because I don't want people in there with the fucked up wrong mindset. It's like, people get so charged, and rightfully so, but anymore, it's like, I'm laughing about what's going on in the courts because you take my truth in there against your horseshit. If you're an attorney, and it's like you don't even have a chance, bro. And I'm not saying that fucking. It's like it's real. I just showed you that. Here comes somebody. They already had me. They had a fucking judgment against me. They didn't have to do any work, but this dumbass is so retarded that he couldn't even hold something that he's got in there. And that's just, dude, that's reality though. You just saw it. You didn't even have to work, bro. You just had to go through the procedural fucking come collect. Now, I would have taken that on completely different. I told you that before we were rolling. Is like, if it were merits based, your fucking foreign lien from California has nothing to do with what we have over here. Meaning, what's that mean? So Article 1, Section 12 in Indiana says, you got free access to the courts and there will be no payment kind of thing. Well, out there, they were making me pay $870. It's a pay for play kind of thing. So that same thing would be against public policy in Indiana. That's how I would have attacked that. And I would have went down that path, and I would have won there too. I would have got that fucking shit reversed. And there may be that. I gave him the opportunity to come on back with your good game there, Robert. And if he goes down that path, then that's where I would take that on. I don't think that they'll want to do that. They've already spent enough money, and for what. That was horseshit too, by the way. The reality of that is I talked a few years ago to the people they were trying to collect off to, and the way my agreement was with them, my dealership agreement, was if you didn't make your first 2 payments, I think now I'm on the hook. But everything after that, so my gal,
reached out to them when I had the dealership, and they gave us the proof that they'd made the first, I think, 4 or 5 payments before they kind of drifted. So one of those things. Hey, let's go try to collect off of Joey. Maybe he doesn't know anything, and that's what most people face, and that's a reality. Is I told you, and this is not all of my consults are for people getting sued for just goofy amounts that it's like, oh my God, bro. Just put in just a little bit of work, learn a little bit of stuff, just follow that little plan that I just showed you on there procedurally. And I honestly, and this is not arrogance either, is I don't think anybody can be beat if they just put just a half of an effort into this thing,
Well, we're building up a crescendo. You and me. I mean, remember back at the beginning of 24, I was filing in Title 18 claims. I mean, come on, you really gotta.
No private right of action.
We really have to sit. You really have to sometimes. I think it's good. I think other people should too. Even if you're not in the legal world, I think just in general, this is almost like part of life, part of meditation. You gotta take a moment and review your life over the past couple of years, 2-3 years. You'd be surprised how good of a parent you are. You'd be surprised how good of a whatever you are. You'd be surprised how much better you've gotten at things, or how much you were drinking before and now you're not. You maybe didn't even notice, or whatever it is. Whatever it is, you'd be surprised. I mean, I was filing in Title 18 causes of action only 2 years ago at this time of the year. And now, I mean, the idea that, and I see a lot of other people starting on their journey, and what's the first thing they want to do? They want to file in 18 USC 242 and 241 charges. Just like me, right out the gate. And I'm like, oh, shit, I did that. First thing I did when I was out the gate, And now the idea of filing a Title 8 is just insane. I mean, that's so ridiculous. It's just like, oh, that's just hilarious. It's just like, that's hilarious. I mean, slavery, involuntary servitude, there's actually a civil action section in that chapter that gives that whole chapter a private right of action. I want to be clear about that because I have used those. That's how my Amex repeal was built. But besides that, which is a very, very rare occurrence, I haven't seen that anywhere else, Title 18 is for federal prosecutors to use. So
yeah, that's the criminal component.
Same thing with the California Penal Code.
Yeah.
Those are all for, and now what's even funnier is Title 18 and the California Penal Code is to they create information indictments, which is under Hurtado versus California, which only applies to 14th Amendment citizens. So like me, for example, you can't prosecute me under the California Penal Code. You can't prosecute me under Title 18. If the FBI wanted to prosecute me under Title 18, they can't. They'd have to put together a grand jury of white Californians. The white Californians would need to issue a grand jury indictment, and then I would get dragged in front of that jury. Now, that has pros and cons. The pros is it's very, very difficult to indict me. It's almost impossible. The cons is notoriously those courts result in you dying, basically. Like, that's basically the answer to everything. Like, if you did anything, you're dead. That's like,
treason,
it's like,
fuck it.
Treason's still to this day federally is death. I'm talking about you touched kids, you stole this, you did that, you set someone's house on fire, you shot somebody. I mean, not everything is they're gonna. I mean, but if you go in there and you don't have your hat in your hand, and you're not trying to fix things, and you're not trying, you just kill you. That's it. That was kind of like hanging somebody was just basically the solution to everything.
That's Friday night.
So the downside is by the time you get there, you're in some fucking seriously deep water, and procedure and all this kind of goofiness is not going to help you.
Yeah,
nothing is going to help you. You are severely in trouble. Like if you don't walk in there and the ego's not completely gone, and you don't have your hat in your hand, and you're like, look, I just want to fix this. That's how I would handle it. I would never be in that situation, but if I was, it would be like, look, guys, I fucked up. I want to fix it. I'm willing to do this, 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 this. I will repaint every fucking building in town. I will brush all the
Clean the
horses.
urinals.
I will clean the urinals. I will fix everything in the sheriff's office.
Get the bubble gum off the street corner.
Everything's gone. I will pave the fucking streets myself. I will literally drive the fucking truck in here. I will pour the fucking concrete. I will push it around myself. You know, that's pretty much, if you don't do that, you're literally just going to die. That's basically a common law grand jury indictment, essentially. By the time it gets to that point, that's pretty much where you have to be, or that's what's going to happen. And then if you are doing something really bad, like touching kids or you hurt someone, even that's probably going to still result in you being killed. Honestly,
Rightfully so, man. There's that
So-
criminal component that I'm just not interested in either. Even though I'm ready for being pulled over in the car and all that, and having my whole, that's a citation, isn't it, bro? That whole thing. I'm not interested in the criminal component. My work is in the civil world, and I'd like to keep it there. It's like,
Me too.
so I'm not gonna do anything goofy and crazy. And
Because people are like, oh, I just had pot, or oh, I just did this. And I'm just kind of like, I just can't. It's just
Yeah.
not where my heart and soul is, man. It's
Exactly.
just not. Like the gun stuff, I have mixed opinions on that. I love guns. I have guns. I'll carry guns sometimes randomly just because I feel like it. I'm a huge, but on the flip side of that, it's also like it can scare people, right?
Sure, yeah.
Having those things. Some people have them in their bags and they're just kind of rolling around and they'll get something fucking, somehow the fucking safety will get clicked off. It's like, it's guns have to come with a certain amount of respect. They have to be properly holstered. They have to be properly separated from other items that could cause the gun to go off. Someone having a gun in their door panel for their car, having a gun in their middle console in their car, as long as there's not other items there, to me, it's okay. It's fine. I don't, at the end of the day, it's no one has a right to tell another person what they can and can't do with a gun. It's the criminal world, the new world that I think we're building is gonna have a world where it's a basis of educational information. What is an American? What does an American consist of? For example, like the 10 Commandments. So there is a separation of church and state in our country, but we are a Christian country. I'm not a Christian, but I live in a Christian country. So like there are certain points, like for example, respect your mother and father is one of the commandments, right?
yeah,
That should just be implemented as part of the culture and the assimilation of what it means to be an American. And if you don't do that, or you don't want to do that, then you aren't considered assimilated. Like you aren't a citizen of a state. It's not, do not use God's name in vain. That might not fly because that blurs the lines. But there's a lot of secular information that can be brought over. Why can't we make educational material about what it means to properly respect a gun, having a gun, cleaning a gun, repairing a gun, replacing items in the gun that may go bad, making sure the safety works? It's not a matter of if you don't do these things, we're going to cart you off like some kind of animal. It becomes more of like a assimilation. It's more of an assimilation issue. There's not even any information. There's no information. It's just like, oh, to get a gun, you need a permit. And then to get a permit, there's no information. If you don't follow our rules, we're going to arrest you. But the rules are in a giant book this big that no one can read.
that is one thing that I've worked on, and this, and that's funny, is one of the guys in my cohort was coming out to see us in Austin and tried to get a gun on a plane through TSA. He's fucked up ADHD. It's not, he's got medical condition that warranted that, but somehow he got behind TSA with a fucking gun. So what I did to attack it and ultimately get it dismissed, thank God, was I pitted the TSA, which is the feds, against the state, and then there's two conflicting stories. One said the TSA officer said that it was fucking fully loaded. The state says no, it wasn't. So this is like there again. There's my procedural mindset as I'm looking at the laws, both state and federal, because I had the ability to do it. But then I'm also looking at the two morons that are witnesses. Now, if I thought this guy was literally trying to go on there to be a stupid idiot, I wouldn't even have touched it. And I hope all of us
That's
feel
what I
the same
mean.
way. He's like,
That's what I mean.
he fucked up. He knew he fucked up. He's on medication. I created this whole story for him too, and it was like, but it was real. And he didn't think it was any big deal. And this is what a lot of people get into trouble with is like, oh, I missed my court date. By the time he tapped me in, bro, I gotta, first off, we got to get you a continuance because they're going to convert something here to something really fucking serious. And, so anyway, we got that in you got to tell me you're going to show up at the hearings down in Kentucky and all of this stuff. And he did, and he was successful. But I see so many people just doing so much stupid shit.
But none of that in the real world. If the 14th Amendment was gone tomorrow, there is no TSA. You can have guns on your hips. The problem is that do you have a gun on your hip and go on the plane? Maybe you do, maybe you don't. But if you did, it would be a well-maintained gun, and it would be inside of a holster that covers the entire gun, so that like something can't snag on it, and cause it to go off or whatever. I don't, there's different. But the thing is that if we're all state citizens, there is no penal code. And the reason why there's no penal code is because you can't prosecute someone with an information. The only way that anybody can be prosecuted as per the Fifth Amendment is through a grand jury indictment. Hurtado versus California doesn't exist if the 14th Amendment was gone. So the thing is that there is no penal code. So I'm always thinking in my mind with the future, when we have no 14th Amendment, there is no penal code. So how are we going to create this new world, which is really just the old world? How are we going to create our new world, which is the old world? How are we going to create that world? And there's only one answer, and that answer is education, make it fun, public shaming. I think that's also like, I can't arrest you. I can't take you away for being stupid with a gun. If you hurt someone, now you're going to get a grand jury indictment. But if you don't hurt anyone, there's really nothing I can do but public shaming. Public shaming. If I educate you and we have educational materials and you don't avail yourself of it and you're acting in a way that's very unassimilated and it's not really fitting in with how the local people behave and how they want the whole point of the grand jury is to control the environment.
Yeah.
If all the people in town don't like this fucking idiot who just rolled in, the grand jury is there to, but should the person who's rolling in have an informational board that they can look at? It's sort of like, at least they should have like an informational board. And then if they don't read the informational board now at that point, it's like unexcusable neglect at that point. But I feel like we have to have the informational board. We have to have the informational board, and then if you so choose to not view the informational board, you're basically unassimilated. And at that point, there'll be other types of things, public shaming and that kind of thing, and then if it gets worse than that and you actually hurt someone, that's when the grand jury comes into play. That's really what America is. There is no penal code. There is no FBI. There is no police. There's no penal code. There's no IRS. None of these things exist.
They become very real for people whenever they get taps on the door from somebody saying they're the FBI and so forth. I understand the premise, but it's until you live through it's what I hear 9 times out of 9. You don't understand. You and I may not have. I have got the tap on the door by the FBI, and it was intimidating, but. Bring us your tax records kind of stuff. Well, that was the FBI at the shop, but then I've had the IRS too. So I understand the whole anxiety around those groups, anything with 3 letters in it. But
I used to too, but now I just see them.
Bucket.
It's sort of like a movie where it's like an old image of something, and it's sort of like. Sanding out, like an old memory that's sort of like erasing. That's how I see a lot of these 3-letter agencies, because I just see them just
Yeah.
going away.
I think there's a
You know?
lot of folks that have a lot of energy that draws that shit to them. I'm saying this and it's not crazyville. I just don't have any fear for any of those folks because I know I'm not doing anything wrong. If anything, I'd be accused of trying to uphold the fucking law. The rules of the court are the law and stuff. And
But none of that is even like once the 14th Amendment is gone, like there is like the rules of federal procedure that were passed in 1938. I think those actually will reverse. So technically, once the 14th Amendment is here's an interesting comment. Once the 14th Amendment is pulled, we will go all the way back to having two different courts, one for law and one for equity. We actually will. If the 14th Amendment is pulled, we will have equity courts.
yeah, I think that in itself is a presumption. I don't think there's people that are going to move from the way business is done because something is ratified or removed. I just don't. I don't think it snaps back to something that it was. I don't know. But I'm here for it. If anything happens, I'll be glad to see it.
I spend a lot of my time thinking about and picturing myself inside of and solving the problems of the new world, which
Yeah.
is really just the old world. The new world is really just the old world. The new world is just 1830. That is the new world.
Yeah.
I think the world that we're moving into is 1830. With cars and with the internet and with cell phones, it's just 1830. It's like cyberpunk meets cowboys.
We got to get rid of the Somalis and Pride Month, both of those things. And then
Well, if the 14th Amendment is pulled, everyone who's not white basically loses everything,
oh shit.
which is a whole nother issue.
Yeah. Yeah.
That's going to need to actually be addressed, though. That's not something
Well-
that's going to that I think everything else can collapse, but that one single point, I think that's actually going to be required to actually have to be something's going to have to happen with that one.
I would think so.
Something's going to have to happen with that one.
Yeah, it'd be interesting.
Anyways, long show, 4 hours.
Yeah, another one in the books, bro.
Been a while. Good to have you on. Good
We'll have
to
to do it more often.
yeah. Anything else you want to say to the audience before I cut it off?
I don't think so, man. Everything I think we talked about is good stuff. I know, we talked about Brandon's big on plaintiff role. I am too. Obviously, I have a whole fucking cohort on being a plaintiff. Defendant is something that I've now got a very nice taste for because I think it's super important and I see there's a huge need. And obviously, I think hopefully you guys have seen some sauce there and know that you can handle your shit when people are coming at you and trying to contract with you in any capacity. And then there's a third one that's I think all of us need to do better at, which is get those complaints filed, man, against the judges and the attorneys and doing it rightfully so to where people will take you in, serious. That's the only way. I mean, I hear this so much, and I was a part of this too, by the way, for a while. I think we all are guilty of that, is the courts are fucked up. The courts are, rigged, and that's real, by the way. And by the way, I tell all my people that. It's like, look, motherfucker, when you get in there, you're going to have to work 5 fucking times harder than any of these bar cards, maybe 10 times harder. So that's just the reality. And if you get into that arena and you learn the stuff that we're learning and talking about and doing, it's not coming without fucking working. You can't be a lazy fucking be in there. You've got to hit the procedural component. You have to do things at a new level that you probably won't even understand until you get in there and say, oh fuck, because that guy is getting the benefit, the judge, whether we want to admit it or not, there's a rule there talking about impartiality. It's there for a reason, because they are very partial to the people that they went to school with, and Ted's banging Cindy's, they're all sleeping with each other and all that other shit. So regardless, you're going to work harder than you've ever worked at anything in your life. But honestly, me, I'll be 56 next month, and I can tell you I've been to the top of the corporate ladders with Chrysler and Rolls Royce, been all over the world, and nothing is more rewarding than what I'm doing right now. And I think Brandon would join me in saying the same thing is like, I truly feel like I've got my legacy in place and I can help people and more importantly, my family and friends. And I don't fear anything because I'm not looking at it from a, I'm, whoa, come get me. I'm ready. I'm here for it if it comes. And I know how to handle business. I know how to build cases. I know how to defend cases. It's like when you get there, and it's been a short path for me, just like Brand. I haven't been doing this stuff. I haven't got a fucking active law degree. I didn't go to school for this kind of thing. I just learned it, and I'm still learning it. I think I will for as long as I'm doing it. Just like Brandon's saying, it's like there. Once you think you've got it, you're right there. I go up against 40-year fucking attorneys. I have a hearing at the end of this month, June 30th. It's a motion for summary judgment hearing. They've flown in attorney groups on me once. It's a 40-year fucking veteran attorney who's graduated top of his class at Notre Dame. And the other guy is from fucking Rutgers, New Jersey, and he's the top. It's a 40-year attorney and a 25-year attorney taking on a fucking bearded guy in Kokomo, Indiana. It's like, so there's something there, and it's Sonny asked me that. He's like, what's it like taking on whole fucking teams of attorneys? And it's not hard. Just get in there and start speaking the truth and watch what happens, because they can't stop the truth, bro. I mean, you take that plus procedure and we talked about this off camera. There's so many fucking people that are wanting to say so much stupid shit. And you don't need to. Like, especially in my 1681 stuff, just talk about the fucking inaccuracies. The law is very clear. It must be maximum accuracy, and there's lots of other intricacies in that law, but the relief is simple. Fix or delete. There's no third option. Fix or delete. That's your two choices, motherfuckers. And they don't do it, and there's investigations that don't happen. I have all that through my Snap-on case. The ACDVs is what it's called. So, I mean, pick a fucking lane, get really good at it. I feel like I'm pretty good at 1681. Brandon's taking his lane and doing his thing. And, there's just so many lanes that you can grab and just fucking, I've had people call me for foreclosures. God love them. I mean, it's just not my lane. And I'm not saying I'm not interested. I feel for them. I truly do. Because I know the emotional roller coaster that is. I need to see somebody rise up and be the motherfucker like me that's over there doing the foreclosure work. And I know there are people out there because Brandon's got some fans. One of them in particular, he reaches out to me and we talk shop. He's a good dude. He's in Florida. He's killing the game as far as foreclosures go. Good for him, man. I hope more people rise up and do that, and there's just so many fucking things that are, somebody can rise up and be the property tax person, and learn all of the stuff.
It's
so
really
many
just the
guys,
trifecta.
bro.
I mean, you may not agree with me entirely, but I think maybe you do. It's the trifecta: procedure, negotiable instruments, and citizenship. Like, to me, everything is just those three things. If you're in a mortgage, then you have you say the citizenship stuff is not relevant, but I think it is, and I'm trying to make it more understandable that it is. I think that's really the biggest barrier. For example, like you saw in this new thing, now I'm explaining it in a whole new way where it's like state citizens are actually under Article 1, Section 10, because what the fuck happened to Article 1, Section 10? What the fuck happened to it?
Right.
It was never repealed. It's part of the Constitution. No state shall make anything but gold and silver coin, a tender and payment of debts. What the fuck happened to that? If you don't explain citizenship, you can't answer that question. It's physically impossible to answer that question without involving citizenship as part of the explanation. Negotiable instruments is obviously a huge part of everything, whether it be taxes, whether it be mortgage. And then you can have all the negotiable instrument and citizenship information on the planet, which is me, as probably who has more of that than anybody else on the planet. And you're still going to lose left, right, and center if you don't have the procedural aspect. And that's something that took me a lot of getting my ass beat to finally admit and understand and be willing to take that on.
I don't think there's anything wrong. We're aligned 100% on the citizenship stuff. I think it's nice and it's great for you to know who you are. My only concern is when it comes into the courts, and I can crack some jokes, about people identifying as trannies or whatever it is. It doesn't matter when I get into the court because I've never seen it matter. You know what I mean? It's like I'm saying it's not relevant. I'm happy being a resident of the state of Indiana or a 14th Amendment, whatever. If it made a difference to me getting into the court and getting that case dismissed, you didn't see one mention of my citizenship or anything, or my 1681 cases, nobody in any district. I had one, and you know who she is, file some of the negotiable instrument stuff, and boom, right away she gets dismissed up in Minnesota for sovereign citizen. It was a 7-page order, sovereign citizen vapor money theory that you and I have heard too much about. Came to me, what are we going to do? And I said, take that stuff out, refile it, follow me, and boom, now she's had success. So, maybe that means that it is relevant and important. I don't know, but for me, it just doesn't make sense because I don't get what I want, my relief. I find that barrier that you found too, which is people don't want to talk about that stuff and they'll discount you. And I haven't found that magic formula to say, well, you and we're both working together collectively. We actually have one we're building this weekend. Along those lines, maybe we'll get an appeal. Maybe we'll get some good case law we can use as persuasive authority. Just right now, I don't see it. That's my only concern. I'm not pissed about it, and you're an asshole and I'm an asshole kind of thing. It's like I just don't see where it's relevant to what I'm doing in the courts right now. I understand the argument and what needs to be made if you believe in it, but I
With
don't.
the credit stuff, if someone said they were going to add all that into credit stuff, I would say don't do that. That doesn't make any sense. Because first and foremost, you're not really your claim has nothing to do with negotiating or endorsements. It's about reporting. It's about the information that is called after all of that takes place. Oh, I created a note, and then I was the issuer, and then I negotiated it with these endorsements. But that's not really what your claim is. Your claim is there's a certain reporting after all of that.
Yeah. And
then the second part of it is that state citizens wouldn't have anything to do with any of this. State citizens have nothing to do with the credit system. Because of Article 1, Section 10, no state shall make anything but gold and silver coin a tender in payment of debt. So if I try to use the credit system as a state citizen, I wouldn't go to prison. There's no penal code for that. I'd be violating Article 1, Section 10, and I suppose if someone wanted to put together a grand jury indictment on that, they could. I would need to really harm people somehow by doing that. But really, it would just be ineffectual. That's really what the result of that would just be a big nothing burger. Nothing would come of it. I would be violating Article 1, Section 10. And that's why the sole proprietorship exists, in order to prevent a violation of Article 1, Section 10.
Mm-hmm.
So to me, I don't see any of it as relative to a credit situation, a credit reporting situation. But a defendant of literally any type of any claim, citizenship is the number one most important part of any defense claim, in my opinion.
Well,
Because for two reasons. Number one, if you're the defendant in a criminal case, if you're a state citizen, it annihilates. If the charging instrument is an information, the charging instrument has to be dismissed immediately because it has no relevance, because Hurtado versus California has no basis in law. So you can just obliterate any criminal charge, essentially. That's if it's a grand jury indictment by U.S. citizens, meaning a federal indictment or a state indictment where U.S. citizens were used to create the indictment instrument, that instrument would also be obliterated by a state citizenship defense, because the only way that you could be prosecuted as a state citizen would be a grand jury indictment by other white citizens of your respective state. So if they built a grand jury indictment of white citizens of Arizona against me, that I would just very easily obliterate that charging instrument. It would have to be white citizens specifically of California. And if it's a civil case, if they're asking for anything that's not gold and silver coins, it's an instant obliteration as a state citizen. I can't do that. You're asking me to do something illegal. You can't have a cause of action. A cause of action can't be based on something illegal. That instantaneously obliterates the cause of action. By asking me to pay a debt using legal tender is illegal, so it just the whole thing just explodes. There's no...
The thing I think you need that I've now shown through receipts, and I think this is, and you feel this because people, they want you to fucking do it for them and all of that. I understand that. I've seen it enough, and that's where you get frustrated, rightfully so. Is the very case that I put on there right now? You already said how you would handle it. That's what we need to see. Is like, okay, Joey's handling it procedurally this way, relying on the rules. Brandon gets one that looks very similar to that, which there's plenty of those out there, by the way, because I get them in my inbox all the time. Fucking, do the negotiable instrument, kind of a thing, and see if that works. Just like that did, the procedural component of what I showed earlier,
The reason why I don't do that for somebody else is because, and you know this, once you take the reins, they're just going to force them even more into your hands. Once you take the reins,
yeah.
Whoever's there, they just want to and if it gets crazier and bigger and worse, they're even less, they back off even more and more. It's just like once they hand it to you, they just back off more and more forever. They're gone.
Yeah.
They might as well just not even. And then a hearing comes around, and then now what do we do?
Mm-hmm.
You don't want to be there.
Saying.
You don't understand. I took the reins. Oh, Brandon's got it under control. Now we have a hearing. Now what do we do? Now recently I had this huge breakthrough on practicing law without a license. Is there going to be a certain point where I get bored and I decide I want to test that, maybe with a friend or something like that? That's very possible that I might go in that direction, right? Yeah. But there's also the possibility that Carl gets his sanctions here at some point, because he's going to keep asking for sanctions over and over and over.
Get to test it that way.
He keeps asking. He's asking for more and more every single time. Will he keep asking for more and more and more? I don't care. You could ask for 15 trillion. It's literally completely irrelevant to me. Ask for 20 trillion. Ask for the entire. What does the whole United States owe the Federal Reserve? Ask for the whole thing. I don't care. It makes no difference to me. So if he asks for 15 or 20 grand, and at some point along the line, maybe the ninth amended complaint, he gets an approval for $50,000 in sanctions, well, then the party starts. The party starts right there. But there's a part of me deep down, I know that most people have no idea about a lot of this stuff. But there's a part of me deep, deep, deep in my soul that believes I will never get sanctioned for two reasons. First off, I'm well-dressed. I'm extremely professional. I fix everything. If you tell me one time to fix 9 things, I print it off, I write all over it, and I very, very carefully sit down and I fix each individual item, and I double-check the list several times to make sure each item is completed. So why you would sanction me is fucking insane. That just doesn't even make sense, right? And the second reason why I truly believe deep down, people know what's going to happen if they sanction me. So if I was just a complete fucking asshole, that'd be a different story. But you kind of have these two things. You have you tell me to fix anything, I immediately fix it. And it stays fixed forever, pretty much. And you know exactly what's going to happen if you sanction me. You know exactly what's going to happen.
Well, that'll be the test that, that's good. Honestly, I've had those tests. I know you have too. Is to say, okay, motherfuckers, now here it is. It's live. This is what you've been wanting all along. I've tested it. It's successful and all of that stuff.
nobody's able to take your level of research and knowledge and apply that, is what I heard right there, as well as you can. Just like my shit too, same thing. It's I just don't see somebody jumping in there, and maybe I'm wrong, and doing what you're saying you'll do and proposing what you'll do. I believe you will, which is, submit fucking payment, via your way when the court sanctions you, if they do. But somebody could use that very same thought process and procedure to do the very credit card, or the credit case that I just showed you earlier with me. So I'd love to see somebody try it and see what happens, but it's got to be them doing the work and not Brandon or.
Well, that's why I'm learning procedure, because to me, it's like, why choose one lane or the other? Why not master both lanes? Why not? You have citizenship, negotiable instruments, and procedure. Why not master all three? Every time I go in and I file something, I'm learning a tremendous amount. I'm able to explain things in a different way. How do I explain this? How do I explain that? I have to explain it to the judge. How do I spin this? How do I do this? How do I implement new research discoveries? Even with this new amended complaint, by the beginning, I was pissed that I had to do it. But then after I started doing it, I was like, oh, wow, this is really a lot different than anything I've ever written before. And by the end, I was like, holy shit, this is actually, this is a whole new level of wow for me, right? Mm-hmm. So it's like a video game. You go out, you fight, you collect experience points, and then you have different skills that you put your experience points into. That's all I'm doing. I go out and I fight. I gain experience, and I go boop, 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 boop. I go 2 points into citizenship, 3 points into negotiable instruments, 2 points into procedure. And then I go back and I fight. I get experience. I come back. I go boop, 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 boop. And as far as I'm concerned, at this point, it's just a matter of time. Mm-hmm. It's just a matter of time. Something's going to happen at some point. It's just a matter of time. What is it going to be? Me getting sanctioned, and then we go down that road and we do all that? Is it going to be me winning something? Is it going to be me settling something? Is it going to be somebody else maybe somewhere trying something, and something is eventually going to happen? Mm-hmm. And that's all I operate off of. That's all I don't need to know anything else. Do I want to go out of my way or take over someone else's case or act like an asshole to get sanctioned? No, I want this to all happen very naturally, and it will. And we're not in any crazy hurry. I don't need to flip out and do something weird to try to make something weird happen. It's like people tell me, oh, why don't you just get pulled over? I'm not going to, I drive 100 miles an hour in the carpool lane by myself. That's enough. I'm not going to go beyond that. This is all going to happen naturally. We live in this cell phone world where everybody wants everything to happen by tomorrow afternoon. Dude, this train is moving so fucking fast, in my opinion. There is so much happening. You've got writs of mandamus. You've got shit coming down from the Supreme Court. Joe Lusika's got all sorts of crazy-ass shit he's doing. I'm doing crazy-ass shit. Tons of people are suing the fucking cops all over the country with Cameron Wilson and Wisedome and all. We've got crazy. We've got talks with the Supreme Court about birthright citizenship coming up this month or next month. Most likely they're going to come back with a final opinion on that. We could see a complete change in the entire definition of what it is to be a 14th Amendment citizen in terms of there's so much occurring. And I think that rather than trying to do something crazy judo over here, I think we should just keep doing what we're doing and just keep the train on the tracks and just keep chugging along, because I don't think we have a whole lot of train tracks left before we're going to start seeing some real shit happening.
That's good. Yeah, the logic's there, Mm-hmm.
So there it is.
Yes, sir.
All right, my friend. Always a pleasure having you on.
Yes,
and
sir.
We should probably do a show more often than, because
Yeah.
I think the last time we did one was 4 or 5 months?
It's been a while.
6 months?
Yeah. Maybe,
It's been
a
while.
little longer.
Yeah, and there's always stuff moving in both of our lives, which is good. We got some shit happening. I've got some good stuff going case wise. So yeah, there's always some updates and stuff that.
Well, you've got like fucking 9,000 things going on. Dude. I'm bringing it all in. I'm just gonna do. 2024 was brutal, absolutely
Yeah.
brutal for me, and 2025 was. Yeah, I'm City of Glendale, MX appeal if that flies, and then maybe little things here and there. But the rest of this year, I may go for one of your 1681s, like maybe next year or something. I think next year maybe I'll get kind of put my arms back out again. But this year
Mhm.
I'm done. I'm
It'll be a
gonna,
fun one, man. Get
yeah.
you some business credit established and just go fucking batshit nuts with, ads and stuff like that, and pay with the negotiable instruments. So there's a lot of fucking stuff you can do over there with that
Yeah.
1681 stuff. I mean,
So I kind of want to get
especially
into
for you.
that, but like filing a bunch more suits like this year is just not.
Yeah.
I'm like coming down off of so many. And the rate of certiorari was really, 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 really taxing. Time wise,
I'm sure.
financially,
Hmm.
emotionally. I mean, it was a complete fucking nightmare. Like I literally feel like my adrenals were like fucking shot when I finally got it docketed. Like the day it was denied, it almost felt like it was nice to it was just over.
Yeah, that is a relief, bro. You did. You got kind of sniffles and sickness every time I talked to you there for a while. It seemed like, and I don't know if that's from the writ or if you just kind of got fucking AIDS or whatever you guys do out there. I don't know. So
I had to get ready for June, man.
Juneteenth. Oh, happy Juneteenth too, bro. Fuck. Oh, jeez.
But regardless, it's a lot of exciting things. You've got a lot of exciting
Yeah.
things. We've got a lot of other people doing stuff now. The 3.0
Yeah.
course is all about litigation and the rules of evidence and the rules of civil procedure. So we're starting to see people roll off of that and kind of run off and do their own things. And
Hmm.
we're starting to see groups. We're starting to see, Cameron Wilson is starting to issue all of these traffic reform bills. We're starting to see
Good.
the elimination of property taxes in places like Florida, and there talks about that in other places. And inflation's getting out of hand, and there's talks about that. It's just we're going to see a lot happening, both with us and our platform and our ideas and the courts and the whole country and everything. It's just going to be over the next handful of years. I think we're going to see a lot of cool stuff. So.
Yeah, it's exciting, dude. I'm glad to be a part of it, man, and I know you are too.
Oh
And
yeah, me too. Yeah.
it's an exciting world to be in, and I just wish more people were not so intimidated by the litigation stuff. And I hope that when they see you and I kind of getting in there and actively doing some of the wins, losses, whatever it is, it gives them a little bit of confidence to say, "Fuck it, I can do this shit too," and yeah, I think that's important. I think that's the only way that we kind of move the needle is we all jump in there and start. That's 100% what we're definitely aligned on that. We got to do something. It just can't stay the way that it is. And
Oh
there
no,
are
absolutely
courts,
not.
there are
Absolutely not.
courts, and if you're not in there maintaining your courts how you want them to run, fuck it. We got some stuff going on in there that none of us like, and it's up to us to change it, man. Not like crazy fucks.
They've been running around with no supervision, like children
Exactly.
at the it's like multiple generations of no
Hmm.
supervision. It's like they're like the great grandkids of great grandpas that didn't have any fucking supervision. There's probably been hardly
100%.
any supervision in the courts since the end of the 1800s.
Yeah, I would say
So
that's right.
a lot of times people come to me and they talk all this mad shit about the courts. I'm blown away they're even still there.
Right?
I think of it the other way. I'm like, I'm not mad at them at all. I can't believe that they even held it together. They've had no oversight.
It's
And
goofy.
and there's only one reason why that is. Do you know what that reason is?
No,
The
I'd love to hear it.
Constitution.
Oh, yeah.
If we did not have the Constitution, this country would have been completely melted down, burned, and exploded 150 years ago.
Probably some reality in that, no doubt about it.
So,
Yeah.
all right, good sir.
All right, bro. We'll do it again soon. Take care.
See you later.